Committee of the Whole, please come to order. Mr. Majority Floor Leader.
What a group we have here, Mr. Chairman. Mr. Chairman, I move that the Committee of the Whole begs leave to rise and to rise and sit again for the purpose of concurrence. And enroll acts.
You've all heard the motion. All those in favor, please say aye. All those opposed, no. Motion passes. Mr. Speaker.
We have messages as well. We are at that order of business of signing of enrolled acts. First enrolled act for our consideration, enrolled act number 53. Reading clerk.
House Enrolled Act Number 53, being original House Bill 122, an act relating to counties, amending the length of time for approval of a mill levy proposition for senior citizen service districts, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 53, having been original House Bill 122. I have so signed. Congratulations, Representative Connolly. Next is a Senate Enrolled Act number 59.
Senate Enrolled Act Number 59, being original Senate File 127, an act relating to administrative procedure, requiring the completion of economic analysis for major administrative rules, amending the process for legislative review and notice of rules, making conforming amendments, specifying applicability, requiring a study and a report, providing an appropriation, authorizing additional positions, and providing for an effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 59, having been original Senate File 127. I have so signed. Next enrolled act 60.
Senate Enrolled Act Number 60, being original Senate File 69, an act relating to taxation, establishing a homeowner property tax exemption, specifying applicability, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 60, having been original Senate File 69. I have so signed. That completes our enrolled acts at this point. We will be doing this through the course of the day, taking a quick break, trying to get these done, going on to some concurrences. Yes. Yes. Representative Bratton, please.
Thank you, Mr. Speaker. I am so pleased to be joined today in the east balcony by my daughter, Chelsea, my son-in-law, Kyle, who is a University of Wyoming graduate, and my beloved grandchildren, Evelyn, Titus, and Gemma. Please welcome them to the House.
Welcome to the House. It's good to see little people. It's always fun. Looks like you're looking into a big fishbowl. Glad to have you. So it's wonderful. Okay, messages from the Senate.
Message number 411. Mr. Speaker, the Senate did vote to recede from non-concurrence on House amendments to the bills listed below by the vote indicated. Senate File 103, terminating and defunding diversity, equity, and inclusion. Ayes 27, noes 4. Message 412. Mr. Speaker, House Bill 79, bond elections, voter threshold requirement. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 30, noes 1. The Senate respectfully asks the House to concur by adopting the listed amendments. Message number 413. Mr. Speaker, House Bill 90, anthrax outbreak protocol. A House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 29, noes 2. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 414. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 122, Senior Citizen Service Districts, Authorization and Renewal. Ayes 29, noes 2. Message 415. Mr. Speaker, House Bill 117, Omnibus Water Bill Construction. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 29, noes 2. The Senate respectfully asks the House to concur by adopting the listed amendments. Message number 416. Mr. Speaker, House Bill 154, false voting amendments. The House bill listed below passed on third reading in an amended form as follows by the vote indicated. Ayes 29, noes 2. The Senate respectfully asks the House to concur by adopting the listed amendments.
Thank you, Reading Clerk. Next, we have concurrences. We are at that order of business of request to concur with Senate amendments to House bills. The first message for our consideration is message number 413 on House Bill 90. Representative Banks, Vice Chairman, please.
Thank you, Mr. Speaker. I move message 413 on House Bill 90 and ask for an aye vote to concur. This is a very easy fix. What they did is change the language from non-negative and insert positive. So non-negative language is only in reference to brucellosis. And so to make it jive with this bill that's about anthrax, it was just simply switched to positive. So that's the only change. Ask for an aye vote on concurrence.
Thank you, Vice Chair. Any discussion? Any discussion? Seeing none, we are voting on the motion to concur with Senate amendments to House Bill 90. A majority of the elected members is required. Chief Clerk will please call the roll.
Allemand. Andrew. Angelos. Banks. Bear. Brady. Bratton. Brown Gary. Brown Landon. Byron. Campbell Elisa. Campbell Kevin. Chestick. Clauston. Connolly. Davis. Eklund. Erickson. Filer. Geringer. Guggenmoss. Haraldson. Harshman. Heiner. Heft. Jarvis. Johnson. Kelly. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storr. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Webb. Weber. Worf. Williams. Winter, excused. Wiley. Yin. Mr. Speaker. Filer, excused to aye. Further changes, Storr. Storr, aye to no. Storr, aye. Are there any changes? Closing vote. Vote closed. 58 aye, 4 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 90. Next is it, I do believe. I don't have any other concurrences, so we're good on that. Yeah, is anyone ready for concurrence? Representative Knapp. Here you go, Deb. That goes to Katie. Next message for our consideration is message number 412 in regards to House Bill 79, bond elections. Reading clerk. Or no, excuse me, we don't need a reading clerk. Representative Knapp, please.
Mr. Chairman, I would move message 412 on House Bill 79, bond elections voter threshold requirement, and ask for an aye vote on concurrence. Basically, what they did on page 3 was removed a sentence that had to do with when the election was to be held after the bond issue, and struck the line, but not less than 12 months following this bond election. After consulting with the bringer of the bill, I would ask for an aye on concurrence.
Any discussion? No discussion? Okay, members, you are voting on a motion to concur with Senate amendments to House Bill 79. A majority of the elected members is required. Chief Clerk, please call the roll.
Allemand. Andrew. Angelos. Banks. Bear. Brady. Bratton. Brown Gary. Brown Landon. Byron. Campbell Elisa. Campbell Kevin. Chestick. Clauston. Connolly. Davis. Eklund. Erickson. Filer. Geringer. Guggenmoss. Haroldson. Harshman. Heiner. Heft. Jarvis. Johnson. Kelly. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas, excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez-Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Excused. Webb. Weber. Worf. Williams. Winter. Excused. Wiley. Yin. Mr. Speaker, are there any changes? Brown, Landon, no to aye. Further changes? Further changes. Closing vote. Vote closed. 52 aye, 7 no, 3 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 79. Okay. One moment, please. Okay. All right. Mr. Majority Floor Leader, we're ready to go back in. Representative Brown.
Committee of the Whole, please come to order. Next bill for our consideration is Senate File 44. Reading clerk, please read the bill.
Senate File 44 is sponsored by Senator Schuler. Fairness in Sports, Intercollegiate Athletics, an act relating to education. Mr. Speaker, your Committee Number 4 Education, to whom is referred Senate File 44 engrossed. Fairness in Sports, Intercollegiate Athletics. Respectfully report same back to the House with the recommendation to pass with the following amendments. Ayes. Representatives Andrew, Bratton, Erickson, Guggenmoss, Kelly, Lawley, Singh, Strzok, Williams. Representative Andrew, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Andrew?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so at the recommendation that Senate File 44 do pass, and I further move the adoption of the Standing Committee Amendment and turn over the explanation of the Standing Committee Amendment to the good Vice Chair of Education. Thank you.
Vice Chairman Lawley.
Thank you, Mr. Chairman. The Standing Committee Amendment is going to bring into this bill language that we already overwhelmingly approved in this body in our bill, House Bill 60. And so again, I guess we'll have further explanation of the bill, and then I will bring the amendment in more detail of how it fits in to the current bill.
Sorry. Representative Harshman.
Thank you, Mr. Chairman. Members, Senate File 44 is before us today. The bill's main sponsor, the senator, little history, she's really one of the pioneers of Title IX when it became federal law, and in the state of Wyoming was a real pioneer, one of the first female athletes in the state, and then one of the first coached for decades, is in the Wyoming Coaches Hall of Fame, and she sponsored a bill similar to this for athletes 7 through 12. At that time, I think there was still this influx about what the governing bodies of college athletics might do, or maybe even Congress or others. But so 2 years have passed now, and so this standalone bill, I think, is appropriate, and we're really talking about fairness and safety, and so the bill itself, as you flip through it, is pretty straightforward. I think it has the definitions on page 2 and 3, and then it talks about there's a standing committee amendment that I think really updates some of the definitions to what this House has done, and the good Vice Chair of Education will explain that. I think it does the bill well. But I think the main thing is that our universities and colleges cannot knowingly compete in these events. And, you know, maybe there's an event, it's a cross-country running event, and our university doesn't know. Hundreds of athletes running one course. And so that's a different situation, but I think the one that made headlines this year that we all that's what we're really focused on this. And so, again, I think it's about the fairness piece. Many of us are parents with daughters who put in unseen hours preparing themselves, and I think it's a fairness and a safety issue, and this body's been very supportive. So the bill is really solid. I think the Standing Committee amendments updates the definitions and does well. And Mr. Chairman, I think the Vice Chair of Education can explain the Standing Committee amendment. So I'd urge an aye vote on both. Thank you.
Vice Chairman Lawley.
Thank you, Mr. Chairman, and thank the good representative from the Windy City in the middle of the state. There's also the number one in our hearts. So I want to join in commending the bringer of the bill, the senator, good senator. I've worked with her a lot. I worked with her on the original sports bill on this side, and so we've worked a lot together. She took a little bit of different approach than the bill we had here, House Bill 60, which had an untimely death over in the Senate. And so she and I have talked about these amendments and trying to kind of put together the two bills a little bit, and because the bill we overwhelmingly passed in this body to address this really important subject of safety and fairness in women's sports address some issues that were not addressed in the current Senate File 44 before you. So what we've done is taken the language out of House Bill 60 that we overwhelmingly passed and bringing it into this bill to shore up some areas. And you'll see on your standing committee amendment We first start with biological definitions of male and female. And then one of the other things that we do, and you're going to see in a minute another amendment that's going to bring in a definition of what an individual sports is in a committee of the whole amendment, because I forgot that when we were pulling this over in committee. But the other area, other than the definition, biological definition of male and female, is the bill before you, Senate File 44, did not really directly address the issue of will female collegiate teams play other teams from other schools that have a known transgender player. That just isn't addressed in Senate File 44 as it sits before you. But what we passed very specifically did do that. So we are bringing over, I'll say, an amended version of that language, and talking with the university across the hill, especially about how we crafted the language in a way that was workable for them in terms of it had to be known. There was no duty to investigate in either situation. But so we're bringing over, and that's where you'll see on your amendment, Standing Committee amendment, on line 15, you will see then where we add that, where it says participation in any athletic competition designated for students of the female sex with or against a team that the education institution knows has a team, that on the team a student of the male sex. So we're just kind of saying we're not going to do that. As the other good representative who brought the bill a moment ago talked about, that this is really addressing some specific things that have happened and try to speak clarity with what our policy is here in Wyoming. And then we also address, and this is something that comes out of our House Bill 60, but what do we do about sports that are considered individual on one level, like a swimming team, for example, is a really good example. A track and field team, a really good example. How do we manage that? What will our policy be about that? Well, our policy, as you'll see it there on line 20, is really that the institution of education will, which is our community colleges and our university over the hill, they will decide how to handle those on a case-by-case basis based on factors of safety and fairness. So for example, there could be situations where a female swimmer is put in a situation of competing against a transgender swimmer from another team, but there are reasons that that swimmer would want to swim, whether it's to get time that she needs in terms of her own statistics that really affect her own opportunities, and that's really for the university to sort out, not for the legislature. So we just let the university do that, knowing and understanding and agreeing with really the objectives of this, that women should not be forced to compete against transgender players. But in those situations where there's not particularly a safety issue, there might be a fairness issue that could work either way. And so we're gonna let those nearest that situation work it out. So the other thing I add that actually wasn't from our bill, but would have been a good thing to have in there actually, is on line 35, you see a person may seek declaratory and injunctive relief against an educational institution for any violation of this section. And the court may order injunctive or other equitable relief, and the court may award the prevailing party reasonable attorney's fees and costs. We want to have some teeth in this. This missed some of that teeth that was in House Bill 60, but I felt under the circumstance of how this bill is crafted overall, this particular kind of relief was the most important. Always the most important is to be able to come forth, and there are some other, by the way, in this bill, there is some other damages in there. There is some other cause of action, but oftentimes in these situations, the most immediate thing is to go into a court and get injunctive relief that either commands someone, declares for someone to enforce the policy, or enjoins them in doing something that shouldn't be done. So that's what that does. And with that, Mr. Chairman, I stand for question on Standing Committee Amendment number 1 to Senate File 44.
Thank you. Any discussion on the amendment? Seeing none, question being called. All those in favor of Standing Committee Amendment number 1 to Senate File 44, please signify by saying aye.
Aye.
All those opposed, no. Standing Committee Amendment number 1 has been adopted. We are now on to Committee of the Whole Amendment number 1. Vice Chairman Lawley.
Thank you, Mr. Speaker. Again, as promised, this is just bringing in from House Bill 60, the definition of individual sport that we had there, and that will help that clause we just talked about be clear as to what it applies to and how it will work. So again, I would just ask for your aye vote on Committee of the Whole Amendment. I probably didn't move it, did I?
Did
Oh,
not.
you should have caught that, Mr. Chairman.
I'm waiting.
Mr. Chairman, I move Committee of the Whole Amendment number 1 to Senate File 44, and I ask for your favorable consideration. Yeah, there you go, question.
Question being called. All those in favor of Committee of the Whole Amendment number 1, please signify by saying aye. All those opposed, no. Committee of the Whole Amendment number 1 has been adopted. We're back on the bill. Vice Chairman Lawley.
Thank you, Mr. Chairman. Ladies and gentlemen, I believe that the 68th legislature needs to speak into this issue, and I believe we need to speak into it with clarity, with clear definitions, and with certainty of policies for the institutions who will have to carry it out. I think the changes we've made to Senate File 44 meet those requirements, and again, everything we pulled over except the redundant language, we have already overwhelmingly approved here. So I ask for your aye vote on Senate File 44.
Any discussion? Representative Campbell.
Moving slowly after lunch. Thank you, Mr. Chairman. So question I would have, with the addition of the amendment, I guess I would ask about the intent of the file started on 44. We have their intent in front of us, and now we have added to what we had in a bill that they did not approve. So I'm curious as to how, I mean, if the original bringers and how they will feel about those additions, and if it will just end up causing more problems for this bill. Thank you.
I will slightly hold us back that we will not refer to what the other actions of the other body may or may not do. Representative Lawley, if you would like to opine beyond that, you're welcome to.
Thank you, Mr. Chairman, for that great invitation. I will just say this, that I've spoken to the sponsor of the bill. She's aware, and as far as I know, does not have any objection to any of what we're doing. We actually, that was what we were wanting to do there, was kind of put the deals together, but the committee ran out of time, and it's actually technically still pending. It's not really dead. They did not vote on it, so that would not be a correct characterization of what happened, and I think this is getting the job done. It's another example, friends, of how we can work together to legislate good policy and have outcomes that the people of Wyoming want us to have. With that, I'll say please vote aye on Senate File 44.
Representative Jarvis.
Thank you, Chairman. So I just have something that I want to throw out there, and I don't know how to amend this to make it work, but I had a kiddo, my youngest, played football last year for our one of Natrona's 2 high schools. And with that, had an absolutely incredible year. And it came down to his accolades from the year before to this year being very different because he missed one little game. And in his junior year, it dropped the stats of where he landed significantly because of that one game. But in his senior year, he was the #1 defensive player for the state of Wyoming in 4A football. Had he, and I'm just throwing this out here, because had a child had to sit out and miss that one game, there are times where those stats matter. And it's not necessarily in competition, because I don't disagree with this bill, and I don't disagree that competing isn't an equal playing field. But I do disagree with forcing our kids to not be able to participate because it does impact them in those types of situations. And I don't know if there's a way with their individual sports when they're collecting those stats. And that is the difference between a nationally ranked statistic and not. I struggle with this one a little bit in that realm because there are very different opportunities that are provided for you when you have the opportunity to obtain those types of accolades. And in these situations, we're talking college athletics, so we're talking the difference of getting the opportunity to go pro or not, or to continue, or to be able to go from a junior college to a very different scholarship-wise, just as much as that scholarship can be impacted by playing against and not a great playing field. When you're talking individual athletics and when you're talking statistics and those stats, I'm struggling with this one. Thank you.
Question being called. All those in favor of Chairman Andrews' motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 44 do pass, please signify by saying aye. All those opposed, no. Senate File 44 has passed committee of the whole. Chairman Rodriguez-Williams,
Thank you, Mr. Chairman. Privilege of the floor.
please go ahead.
Mr. Chairman and members of the body, we have some special guests in the House today. I'd like you all to give a warm welcome to some of the members of the University of Wyoming rodeo team who are here today to celebrate the bill signing, which was Senate File 121, the rodeo license plate bill that you all supported and was signed today by the governor. I'd like to introduce some of the team members that are present today. We have Reagan Delancey, and her events are team roping, barrel racing, breakaway, and she's at UW on a rodeo scholarship. Then we have Alex Bolton, and her events are barrel racing, and she helps with the team public relations. And then we have Abby Youngvorst, and her event is barrel racing. So welcome, ladies, to the House.
Welcome to the House. Representative Bratton.
Thank you, Mr. Chairman. I would also like yet another privilege of the floor.
Please.
Again, in the east balcony here, I am pleased to welcome friends from Sheridan County, Gary and Susan Miller and Tracy Boyle. Susan and Tracy are on the board of the UCross Foundation, and they have both served on the National Advisory Board for the Brinton Museum. They are here for the Governor Art Awards tonight, where I will join them in honoring our neighbor, Tim Lawson, who's a celebrated landscape artist. We're looking forward to that. And Susan and Tracy are also my bridge partners. So, well, please welcome them to the House.
Welcome to the House. We hope to join you at the Governor's Art Awards tonight. And that all depends upon how much we talk here. So, Representative Heft.
Mr. Chairman, privilege of the floor.
Please, go ahead.
It's been an honor serving members, and I couldn't be here without support from home. My lovely bride is here, and Rosalie. And last week, we celebrated our 47th wedding anniversary, and I proposed to her that we go 47 more, and she said yes.
Congratulations and amazing work at 47 years. That's amazing. Any other privileges of the floor? Seeing none, back to work. Next bill for our consideration is Senate File 174. Reading clerk, please read the bill.
Senate File 174, sponsored by Senator Driscoll, Constitutional Apportionment 2, an act relating to the state legislative districts. Mr. Speaker, your Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 174, Constitutional Apportionment 2, respectfully report same back to the House with the recommendation that do pass. Ayes. Representatives Brown, Heft, Johnson, Knapp, Locke, Lucas, Webb, Weber, Yin. Representative Knapp, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Knapp?
Mr. Chairman, thank you. I would move that when the Committee of the Whole rises to report, it do so with the recommendation that Bill Senate File 174 do pass. There are no amendments, and I will present the bill. This basically deals with the constitutional apportionment that we have in certain counties where they believe in that we have been violating our constitutional requirement for legislative apportionment. And this deals with the one legislator, one senator per county. And with that, I would take questions.
Any discussion? Seeing none and hearing a mumbling of question being called. There we go. All those in favor of Chairman Knapp's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 174 do pass, please signify by saying aye. All those opposed, no. Senate File 174 is passed. Committee of the Whole. The next bill for our consideration is Senate File 95. Reading clerk, please read the bill.
Senate File 95, sponsored by Senator Rothfuss. Special Purpose Depository Institution Amendments, an act relating to banks, banking, and finance. Mr. Speaker, your Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 95, Special Purpose Depository Institution Amendments, respectfully report same back to the House with the recommendation that do pass. Ayes. Representatives Brown, Heft, Johnson, Knapp, Locke, Lucas, Webb, Weber, Yin. Representative Knapp, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Knapp?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 95 do pass, and with the explanation, I bring the good banker.
One moment, Mr. Chairman, we're having technical difficulties.
Representative Lucas.
Thank you, Mr. Chairman. So I bring to you today Senate File 95, which is Special Purpose Depository Institution Amendments, SPDI, we call them SPEEDY. And this is a type of financial institution, and they're commonly called speedy banks. Think of it as a Bitcoin bank. There are 4 of them in existence in the world, 5 soon. 2 of them are in operation, all of them in Wyoming. So we are literally where no one has gone before. There are some changes to this. Expect that we'll be talking about this a whole lot more in the future, folks, because it is coming soon everywhere. I'm just scrolling really quick here to get to where the meat is. Would be amazing. Thank you. I was caught unprepared because it was my fault. So there's not a lot changing on this at this moment, but we will be working on this as time goes on with some hefty amendments. So there's a change on, if you look at the bottom of page 6, applicability of other provisions. Well, that's kind of just going as otherwise provided in the regulation, but we look down to the bottom of page 6. So there was currently there's a fee or a minimum deposit, if you will, in these banks of $5,000. And it has been challenging at times for depositors. If their balance dips below $5,000, then they get in all kinds of trouble and it must be reported. And so we're changing that to $1,000, and there'll be a tolerance of within so many business days that they have to bring the balance back up to $1,000. The Speedy Banks, by the way, have more than 100% liquidity. They're 100% backed by deposits. They don't do loans. They don't have any risky investments. They don't have anything except deposits. And so it's not really a real bank in that respect. So having a lower threshold for deposits is absolutely no risk for them. And then when we look at page 7, there is a change that their capitalization will need to be at least 20%, and that is quite high for a financial institution. And this is all getting ready for changes that they'll want to make in the future, which we did not entertain in committee because it's quite complex and we'll need a lot more time. So with that, I would stand for questions on this.
We have a committee of the whole amendment, and I have Representative Filer.
Thanks, Mr. Chairman. Right now, I'd like to move committee of the whole amendment number 1 to Senate File 95 and ask for everybody's favorable consideration. As we talk about Bitcoin banks, things like that, a lot of this stuff is blockchain backed. So with this amendment, Mr. Chairman, is what it does is it kind of adds back in something that this body already passed and would bring another $500,000 to the University of Wyoming for blockchain digital innovation and technologies, provided, it's providing that the center develops software for the number 2 executive for initial business filings and all these other things. Because as we go through these types of depository and banking laws, we're going to have a lot more companies that are going to be coming in that are blockchain backed, Bitcoin, and possible other cryptocurrencies and everything like that. So I think it's kind of a good time to kind of fit that in there and push that forward to the other side and see how we can get this appropriation and over to the University of Wyoming, where that department actually handles a lot of the technology, building this technology for our state, so that our top electeds have this capability of using this technology, Mr. Chairman.
Any questions on the amendment? Seeing none. And waiting. Question being called. Thank you. Wake up, everybody. Got after lunch sleepies here. All those in favor of committee of the whole amendment number 1 to Senate File 95, please signify by saying aye. All those opposed, no. Committee of the whole amendment number 1 has been adopted. We're back on the bill. Representative Singh, did you want to talk?
Thank you, Mr. Chairman. Let me just play some leapfrog to the mic I want to stand at. Folks, this was a bill that we worked on in your Blockchain Select Committee. It has been thoroughly vetted over a couple of different meetings, and the task was to create a pathway for folks to, if they had a special purpose depository institution, to then be able to convert that into a trust. This all lives in Title 13. And so then the other half of the bill is all about the new requirements in order to start up one of these special purpose depository institutions. And the good representative whom I share a county with was right. This is the unknown. We are on the frontiers of what it means to hold assets in a digital form. That's interesting part of Wyoming history that we are currently writing right now, and this is part of the work that we've been doing. And so I do welcome any questions about it, and I'm proud of the work that we've done, and I would ask for your aye vote.
Representative Lucas.
Thank you, Mr. Chairman. Yeah, my colleague from my county, we're a good counterpoint on this one. Just to let you know that in committee, we talked a lot with the commission here in Wyoming that deals with banks, and the amendment that they had was quite extensive, quite involved, and quite honestly, folks, we need to spend a little bit more time on this before we jump into, a 5-minute discussion on whether to make a law out of it. So we didn't go to that point. Because we have so few of these, and discussing writing a law on how to help them convert to a different type of institution in a very brief discussion was just quite a lot to handle in that. It's not ready for prime time yet, as I hear us say here. So that piece of it, you really aren't seeing in this bill. It's just a couple of very small changes to an existing law. And so I do ask for your favorable consideration on this.
Any further discussion? Question being called. All those in favor of Chairman Knapp's motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 95 do pass, please signify by saying aye. All those opposed, no. Senate File 95 is passed Committee of the Whole. The next bill for our consideration is Senate File 70. Reading clerk, please read the bill.
Senate File 70, sponsored by Cap Fin. Investment on modernization, state non-permanent funds, an act relating to public funds. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 70, investment modernization, state non-permanent funds, respectively report, same back to the House with the recommendation that do pass. Ayes, Representatives Allemand, Angelos, Baer, Haroldson, Pendergraft, Sherwood, Smith. Representative Baer, Chairman.
Well, ladies and gentlemen, I'm looking around for a chairman, and I do not see a chairman nor a vice chairman at this point. So I'm going to do a light admonishment while we're here. Ladies and gentlemen, we're in Committee of the Whole. We have bills that are presented on the website. Chairman, please be prepared to introduce your bills. Members, please be prepared to explain your bills. And at this point, I still don't have a vice chairman.
Pendergraft is here. He can take that.
Vice Chairman Pendergraft.
Good afternoon, Mr. Chairman.
Good afternoon.
My
You've heard the reading
apologies.
of the bill. What is your pleasure, Vice Chairman?
I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 70 do pass. There are no amendments, no standing committee amendments, and for the explanation of the bill, I would turn it over to the good man from the land of the wheat.
Mr. Speaker Pro Tem.
Thank you, Mr. Chairman. So today we have Senate File 70. So this is again another conversation about clarifying and simplifying some of our different accounts. This one here, though, is a little bit different. We have two accounts that we are combining into one here, and that is the Wyoming Cultural Trust Fund, as well as the Wildlife Natural Resource Trust. And so what we see here, a couple things, and we'll get into the bill, but a couple things that we have going forward is currently in both of these funds, we do not have set amounts of money that is pulled out on a yearly basis. So it is fluctuating in and out depending on what the account does. And so what I kind of, first of all, the overarching is this right here is an opportunity for us to set a certain percentage amount. They've taken it across the board percentage and said each of these accounts produces a certain amount of a percentage that they can pull on. And so if you look on page 6 on line 1, you'll see 3% is the percentage amount set on the Wyoming Cultural Trust. And then if you go on to page, 1 second, let me get to it. If you go on to page 13, you're going to see 4% is what the Wyoming Wildlife and Natural Resource Trust account is set at. And as we talked to both of the directors to these two departments and asked their opinion on this, they said we would really, really love if we set this at a set amount. That way we know as we're budgeting what we're budgeting for and what we're looking at. And so a couple things that this bill does, number one is that percentage. The other is this, it removes the inviolate nature, which gives us higher returns. It takes and creates a spending policy that gives that set amount, stays in pool A, and it gives us an opportunity to combine these two together and give the Wyoming Cultural Trust Fund a little bit more of an interest-bearing ability because we're partnering it with the higher financial level or amount out of that the Wildlife Natural Trust. And so this gives two things. One, it gives us just a cleanup, and then second of all, gives them that stability of knowing what percentage they're pulling. And both the director of the I guess we could, I don't know if it's not in, anyways, the directors of both of these trusts were very much for this, and it had been a 2-year process of making this reality. So with that, I'd stand for any questions.
Any discussion? Representative Harshman, please.
Thank you, Mr. Chairman. On and for the bill. Members, the bill takes 2 of our statutory trust funds, the Cultural Trust Fund, which is, I don't know, 20, almost 30 million. We've just built that in the last couple of years particularly. And then the Wildlife Natural Resource Trust Fund, which has been talked about since the 70s, and we've put the first 100 million in 04 and another 100 million about 3 years ago to get to that goal of 200 million. So we set these up as statutory trust fund models, much like the Permanent Mineral Trust Fund and the Common School Account, where you have a corpus and then you have a reserve amount that guarantees the spending policy. So what we're doing here is making really statutory endowment models. So there will not be a reserve account. It's all going to be one large account invested for total rate of return with a spending policy on that amount. And you might recall we passed a joint resolution earlier this year calling on Congress to amend our Act of Admission on the definition of earnings. Right now it's interest and income, and the whole world has changed. We lived for the first 100 years really with treasury notes and interest income. And now, we're invested all over it. So that needs to change. This is really the forerunner of what the 69th and 70th legislature hopefully can accomplish with the voters of Wyoming to change our constitution to allow our Permanent Mineral Trust Fund and our Common School Account then to become endowment models and modernize these. And that'll take a constitutional amendment, vote of the people, and actions of the 69th and 70th legislatures, which other Western states who have these same trust funds similar to us, really right next door to us, a few of them, have already done this. And you're going to get a higher rate of return because as we have 580,000 people in the 10th largest state, our per capita expenses are high to run an entire state with really the population of the suburb of a city 90 miles south of us. So we're going to increasingly need our trust funds to work harder for us, to be more efficient, and then generate more revenue for us to keep our taxes as, second or third lowest in the country, and to protect our industry from having tax increases in the future. And really, so this is the first step. It'll work well. And then the next step will be coming for those of you in the 69th and 70th. So on and for. Thank you, Mr. Chairman.
Mr. Speaker Pro Tem? Nothing. Any further discussion? Question being called. All those in favor of Vice Chairman Pendergraft's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 70 do pass, please signify by saying aye. All those opposed, no. Senate File 70 is passed Committee of the Whole. The next bill for our consideration is Senate File 38. Reading clerk, please read the bill.
Senate File 38, sponsored by Appropriations, Performance Compensation Investment Performance Amendment. An act relating to the administration of the government. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 38, Performance Compensation Investment Performance Amendment, respect the report, same back to the House with the recommendation that do pass. Ayes. Representatives Brown, Campbell, Lean, Locke, Lucas, Riggins, Storer, Stivar, Wharf. Representative Locke, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Locke?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 38 do pass. And I yield the floor to the representative just to the west of County 1 and to discuss the bill.
Representative Larson Lloyd.
Thank you, Mr. Chairman. Folks, this House Bill 38, or Senate File 38, is a result of an audit that was required of our Treasurer's Office and the retirement system for the performance compensation plans that they had. We, in the audit, we ask, are our performance compensation benchmarks working all right? Are we setting them accurately? Fortunately, very happy to report that the 2 consultants, one for each one of those divisions, came back and said that everything was, the benchmarks were being set accurately, appropriately, and the performance compensation for those asset managers that are now in there was appropriate. They came back with one recommendation. Because we started turning over the investment of some of our funds in-house in about 2017 and created that performance compensation plan, it was based over a 3-year period average, the performance compensation. And those first 3 years was done on an arithmetic average, 1 + 2 + 3 divided by 3. Just because of the short duration of those first 3 years. The consultant says, now that you've got multiple years in, you ought to convert that over to a geometric to take in a more accurate accounting for the compounding and the fluctuations in the market, to where they would be just more accurate in doing the performance compensation. So this bill is following the recommendations of the consultants to do that. Mr. Chairman, I'd stand for any questions.
Any discussion? Chairman Locke.
Thank you, Mr. Chairman, and I'm on and for this bill. Please vote aye.
Any discussion? Representative Harshman.
Mr. Chairman, just a question, kind of the task force, just how is the fund? 15 years ago, we were in real trouble, and now we've became really solvent, is my take on it, and we've actually lowered rates. And so why would we change this benefit for workers in our state? A little more info.
Representative Larson Lloyd.
So thank you for the question. I want the body to understand that this is dealing with the investments, those individuals in our Treasurer's Office and the retirement systems who are investing our assets, and not perhaps workers' compensation like the good chairman might have been thinking about. But I would just share with you that things are going just fine.
Any further discussion? Question being called. All those in favor of Chairman Locke's motion that when the Committee of the Whole rises to report, it do so with the recommendation that, what Senate file were you on? What Senate file was that? 38 do pass. Please signify by saying aye. All those opposed, no. Senate file 38 is passed Committee of the Whole. The next bill for our consideration, sorry, ladies and gentlemen, I moved my location here, is Senate file 53. Reading clerk, please read the bill.
Senate File 53, sponsored by corporations, trademarks and trade names, administrative cancellation, an act relating to trade and commerce. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom is referred Senate File 53 engrossed. Trademarks and trade names, administrative cancellation, respect the report, same back to the House with the recommendation that do pass. Ayes. Representatives Campbell, Heiner, Knapp, Larson, Lawley, Schmid, Tarver, Weber. Excused, Representative Riggins. Representative Heiner, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Heiner?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File Number 53 do pass, and I turn over the explanation of this bill to the good representative that apparently has something to do with charcoal grills.
Representative Weber.
Thank you, Mr. Chairman. Senate File 53 is not an insurance bill. It is a Joint Corporations Committee bill that came out of the Business Fraud Working Group from the 2024 interim and allows administrative cancellation of trade names. Let's see. This mirrors existing grounds for administrative dissolution for for-profit corporations and nonprofit corporations and LLCs. The discussion about this during the interim is that the grounds for dissolution of trade names and trademarks are far more limited than those of other business entities registered with the Secretary of State's office. Senate File 53 as written would allow the administrative dissolution in appropriate instances by the Secretary of State's office so that the holders of trade names and trademarks do not have to expend resources on the judicial process while still allowing for the judicial review of administrative dissolutions. A quick walkthrough at the bottom of page 1 and 2, it amends the statute that contains the existing grounds for cancellation of a registration of a trademark by creating a new Romanet VI that provides for administrative cancellation if it is in the public interest and the registrant has provided false or fraudulent information at the Secretary of State's office. Moving on to page 2, is the process for notice to be sent and a 60-day cure period. At the bottom of page 2 on to page 3, this provides for administrative dissolution if the response does not satisfy the grounds for dissolution. Page 3, subsection D, provides an appeal process for judicial reinstatement. On to page 4, mirrors the same process for administrative dissolution for trade names, providing for notice, the right to cure, and administrative cancellation. And on to page 5, the ability to petition for judicial reinstatement, and contains an effective date.
Any
Stands
discussion?
Thank you, Mr. Chairman.
Seeing no discussion and question being called, all those in favor of Chairman Heiner's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 53 do pass, please signify by saying aye. All those opposed, no. Senate File 53 is passed Committee of the Whole. The next bill for our consideration is Senate File 101. Reading clerk, please read the bill.
Senate File 101, sponsored by Senator Landon, post-conviction DNA testing procedure amendments, an act relating to criminal procedure. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred Senate File 101, post-conviction DNA testing procedure amendments. Respectfully report same back to the House with the recommendation do pass with the following amendments. Ayes. Representatives Brady, Bratton, Chestick, Filer, Kelly, Lean, Singh, Washit, Webb. Representative Singh, Vice Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 101 do pass, and I further move the adoption of the Standing Committee amendment. Turn over the explanation of this fine bill and the amendment to the good representative from County 3.
Representative Bratton.
Thank you, Mr. Chairman. In 2008, Wyoming enacted its Post-Conviction DNA Testing Act. This was part of a national movement due to a number of erroneous convictions that were being overturned with the advent of DNA testing. There are provisions to protect against abuse of this opportunity under the law to request DNA testing after a conviction takes place, as it should. One of these protections is that a person can't make a strategic decision to not pursue DNA testing so that later, if they're convicted, they could come back and demand DNA testing, which would give them a second bite at the apple. This is a good protection against abuse of the law. However, since the legislature worked on that law for a number of years before it was actually enacted, then the particular provision inadvertently retained the date of January 1st, 2000, which was 7.5 years before the law was enacted. This created a donut hole from basically from year 2000 to 2008 when the law was enacted. So as a result, from that period between January of 2000 and July of 2008, a person convicted during that period effectively cannot pursue DNA testing under the law today if the person did not request DNA testing or present present DNA during their trial. So there is one case at least, which has been the driver behind the legislation, which was captured in this trap. The defendant hadn't even heard of DNA testing back in 2000. As a matter of fact, there's probably a lot of us here who didn't even have cell phones and DNA wasn't even a thing. So they were not aware of that, and the public defender did not order that DNA testing. This bill does one simple thing. It fixes the mistake of using a date for this protection that predates the actual law by 7.5 years. It changes the date from 1/1/2000 to 7/1/2008. That's when the date that the law was actually enacted. And with that, I will move. There was one amendment, or standing committee amendment, and on page 2, line 8, after convicted, we inserted on and or, because if you were actually convicted on that exact date, then you wouldn't have been allowed to do this. So with that, I'll stand for any questions.
Any discussion on the amendment? Seeing none, question being called. All those in favor of Standing Committee Amendment Number 1 to Senate File 101, please signify by saying aye. All those opposed, no. Standing Committee Amendment Number 1 has been adopted. We are back on the bill. Is there any discussion? Seeing none, question being called. All those in favor of Chairman Washet's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 101 do pass, please signify by saying aye. All those opposed, no. Senate File 101 has passed Committee of the Whole. Representative Erickson. Privilege of the floor?
Privilege of the floor, please.
Please, go ahead.
I'd like to introduce in the North Gallery today my son, my favorite daughter-in-law, and my newest grandchild named Gannett, after the winner. Yeah, just little. Thank you, Mr. Chairman. He's not quite the Gannett peak yet, but that's what he's named after, so he'll grow.
Well, I don't know if the cameras and everything else caught that, but that was the most collective awe when everybody stood up. So thank you for joining us and welcome to the House. Any further privileges? Moving on. All right, next bill for our consideration is Senate Joint Resolution 4. Reading clerk, please read the joint resolution.
Senate Joint Resolution 4, sponsored by Senator Pearson. Resolution on commercial-based load power generation. A joint resolution requesting the governor concentrate on promoting stable, dispatchable base load power resources from Wyoming in lieu of taxpayers, subsidized commercial wind and solar generated power. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred Senate Joint Resolution 4, resolution on commercial-based load power generation, respectfully report same back to the House with the recommendation that do pass. Ayes, Representatives Campbell, Heiner, Knapp, Larson, Lawley, Schmid, Tarver, Weber. Excused, Representative Riggins. Representative Heiner, Chairman.
You've heard the reading of the joint resolution. Chairman Heiner, what is your pleasure?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate Joint Resolution 4 do pass. There are no amendments, and I turn the explanation of the resolution over to the representative from the town named after a French-Canadian trapper and steamboat operator.
Representative Schmid.
Thank you, Mr. Chairman. Members, this resolution was actually born out of our Lincoln County Republican Party.
We do not refer to the parties. Thank you.
I apologize. But what it aims to do is to make our traditional Wyoming energy industries great again. So I rise today in strong support of Senate Joint Resolution 4, a resolution urging our chief executive to prioritize Wyoming's stable, dispatchable baseload power generation over unreliable
taxpayer-subsidized wind and solar. Wyoming has long been an energy powerhouse, supplying not only our own state, but also the rest of the country with affordable, reliable energy. We produce 4 of the cleanest, most stable sources of baseload power in the United States: clean coal, natural gas, uranium, and hydroelectric power. These resources are the backbone of grid reliability, economic stability, and national security. Unlike wind and solar, which are subject to weather conditions and require massive government subsidies, our traditional energy sources deliver power 24/7, regardless of the time of day or the season. We have already seen the consequences of over-reliance on intermittent energy sources. States that have prioritized wind and solar while phasing out baseload power are now experiencing rolling blackouts, skyrocketing energy prices, and grid instability. Wyoming cannot afford to follow that path. This resolution does not ban wind or solar development, nor does it prevent private investment in alternative energy. But it does make a clear and principled stand that Wyoming will not squander taxpayer dollars on energy sources that cannot meet the demands of a modern industrialized society. Furthermore, Wyoming is in a unique position to export our baseload energy resources to the rest of the country and the world. Our state has a capability to supply clean, affordable, and abundant power, reducing reliance on foreign energy and strengthening our national grid. With Senate Joint Resolution 4, we are sending a message to the top executive, to policymakers, and to the nation that Wyoming stands for energy independence, economic growth, and responsible governance. I urge my colleagues to support this resolution and reaffirm Wyoming's role as a leader in stable, dispatchable, baseload power generation. I urge a yes vote on this. Thank you.
Any discussion? Seeing none and question being called, all those in favor of Chairman Heiner's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate Joint Resolution 4 do pass, please signify by saying aye. All those opposed, no. Senate Joint Resolution 4 has passed Committee of the Whole. The next bill for our consideration is Senate File 57. Reading clerk, please read the bill.
Senate File 57, sponsored by corporations. 911 service reporting, an act relating to emergency telephone service. Mr. Speaker, your Committee Number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 57, 911 service reporting, respectfully report same back to the House with the recommendation that do pass. Ayes, Representatives Brown, Heft, Johnson, Knapp, Locke. Excused, Representatives Lucas, Webb, Weber, Yin. Representative Knapp, Chairman.
Heard the reading of the bill. What is your pleasure, Chairman Knapp?
Mr. Chairman, thank you. I move that when the Committee of the Whole do rise and report, that it do so with the recommendation that Senate File 57 do pass, and with the explanation of the bill, I will give that to myself. The 9/11 reporting, if you recall, there has been some issues at times with 9/11 outages, especially in the last couple of years. And this bill came before us for some amendments. And the bill basically allows for those companies that deal with 9/11 emergency systems, if they have a component that causes an outage, to basically do reporting on it. So on page 2, effective January 1st, 2015, in every calendar year instead of fiscal year thereafter. And then also on the bottom of page 2, same change for calendar year. And the governing body was inserted to have the Wyoming Public Safety Communications Commission, and that is the bill. I would take questions.
Any discussion? Seeing none and hearing a muttering of question out there, all those in favor of Chairman Knapp's motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 57 do pass, please signify by saying aye. All those opposed, no. Senate File 57 is passed committee of the whole. The next bill for our consideration is Senate Joint Resolution 1. Reading clerk, please read the bill.
Senate Joint Resolution 1, sponsored by Senator Barlow. Convention of States, a joint resolution requesting Congress to call a convention for proposing amendments to the United States Constitution as specified. Mr. Speaker, your committee number 4, Education, to whom is referred Senate Joint Resolution 1, Convention of States, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Andrew, Erickson, Kelly, Lawley, Singh, Williams. Noes, Representatives Bratton, Guggenmoss, Strzok. Representative Andrew, Chairman.
You've heard the reading of the bill. What is your pleasure? And I'm going to give a little bit of leeway on this one because this one did come out of nowhere and get moved. Chairman Andrew, you've heard the reading of the bill. What is your pleasure?
Thank you, Mr. Chairman. I forgot this one was mine. I move that when the committee of the whole rises to report, it do so with the recommendation that Senate Joint Resolution 1 do pass. And I turn over the explanation to the good co-sponsor.
Representative Singh.
Thank you, Mr. Chairman. Body, I bring to you Senate Joint Resolution 1, which is a call for the state of Wyoming to join in a convention of states, an Article 5 convention of states. For those of you who might be unfamiliar with this topic, an Article 5 convention of states is referencing Article 5 of our Constitution, which is the built-in mechanism by the founders of this country to be able to execute the changing of the Constitution through amendments, the amendment calling process. And so what it requires is that that there is an assembly of states, that the states come together on a shared purpose, some sort of topic to call a convention for, and then after they reach that threshold, then the states would convene, have a convention, and it would have to go through a rigorous process in order for anything to become the law. And so this is a particular joint resolution, and on section 2, which starts on page 3, it goes through, starting on line 11 on page 3, that there's an application to Congress to call for a convention of states pursuant to Article 5 of the U.S. Constitution. That the purpose of the Constitution is to rein in fiscal restraint upon the federal government for the purpose of term limits on our Congress in Washington, or in, what is it? The capital city over there, that direction. And that we join with the application with other states that are joining in the process. And so I believe there are a lot of thoughts on this particular bill, but I would like to go ahead and stand for any questions.
Representative Kelly.
Thank you, Madam Chair. This is perhaps the most consequential topic that will come across this body, maybe in some of our tenures. We're not talking here about what affects the states. We're talking about what affects all states. Now, my vote on the committee was for a yes, even though I'm completely against this resolution, because I thought it was wrong for a handful of people on the Education Committee to make this decision for the entire state. I wanted reps from all corners of the state to be able to speak about this. This could be the colossally largest mistake we've ever made in here. Now, I understand the national bandwagon towards this. I understand the driving factors. I understand out-of-control spending and out-of-control federal government. I understand career politicians who worry more about their donors sometimes from foreign nations than they do about our own country. I get all of that. But the United States Constitution is not broken. There's nothing wrong with it. The rule book is just fine. When we have people ignoring the rule book, writing new rules won't change anything. And I think of the damage that could happen from this type of convention to the United States because we have this fervor to get the federal government under control, even though we're already taking a step in the correct direction. You see it in the headlines right now. This resolution comes from the United States grassroots not putting up any more with an out-of-control federal government, but we're already pushing back. We don't need to change the rule book. All I can think of is we're tired of people speeding down the highway, violating the speed limit, so we're going to lower the speed limit. That's what we're going to do. We have people already ignoring the rule book, so we're going to add more rules to it. It doesn't make any sense. The potential for damage to this country and the potential for increasing divisiveness as states, like I've said in the past, red states become more red, blue states become more blue. I imagine a nightmare of 3/4 of the states ratifying changes that another fourth of the states who are already putting together a task force to resist the current president, what their reactions might be to things like a balanced budget amendment, to a redefinition of the Commerce Clause, which basically outlaws programs, massive federal programs that are highly popular. I don't buy the arguments that we would lose Amendment 2. I don't buy the arguments that the country would be worse off in general. But what I see here is the potential for very little to actually happen in practicality and a lot of divisiveness. And probably my biggest fear in all of this is not that it would fail, but it would actually succeed. And at the risk of violating decorum here, I don't think we're smarter than Madison, Adams, Jefferson. And we should leave the Constitution as is. And if we need to change it, we have the old method. But this has never been done before. These are uncharted waters. And anyone who says they know what's going to happen is kidding you, because none of us will know what happened. So I urge a no vote.
Representative Yin.
Madam Chairwoman, thank you. So members, so this is a resolution that would basically say, yes, we want to create a convention, send a member to a convention. That convention theoretically would set rules. You know, this body has talked about germaneness to a specific subject many, many times. And we're believing that by passing this resolution, that the convention would stick to the subject that we would set for them in the resolution. So there's a couple of subjects in the resolution for particular things that we would want them to tackle in a convention. The issue with the convention is that we won't get to set the rules of what is germane to a specific subject. So by creating a convention that will then bring proposals back to the states for ratification, they could bring proposals that are way out of the realm of what we would consider necessarily within the subject of the proposal. And so that's my ultimate concern with an Article 5 convention, that just because we say it wants to be on specific subjects, that doesn't mean the convention will necessarily obey that and then bring back proposals. And frankly, even if they brought back proposals where we necessarily believe that they were outside of the subject of the convention, I don't think that there's any room for a court to say that those proposals are not within the subjects of the proposed convening resolutions. So I just want to put that out there for you guys, that calling a convention is serious business. It opens the door to basically the entire Constitution. And the idea that we could limit it to specific subjects, I think is folly on our part. And with that, I'm probably on and against the resolution, Madam Chairwoman.
Representative Stivar.
Thank you, Madam Chairman. On and against,
pull out the U.S. Constitution and look at Article 5. It's a paragraph long. Nobody knows what's going to happen when you go there. We just need to follow the Constitution as written, on and against.
Representative Webb.
Thank you, Madam Chairwoman, sorry. You're right. The Constitution is not broke. And we need to utilize it. We've each sworn an oath to uphold the Constitution. And, you know, it's always said, well, we pick and we choose. Article 5 is in there for us, to help us, we, the people, can help our state and our country to be able to make this country great. Our founding fathers were very cognizant of the separation of powers and checks and balances. An Article 5 Constitution to propose amendments to the Constitution allows us to be able to be in power. We're the grassroots people. We are the ones that ultimately have the responsibility for the direction of this country. We have nothing to fear but fear itself. I remember the first time I drove a vehicle when I was 9 years old, and it was a 1968 Ford truck, blue in color. And I popped the clutch, and my nephew jumped out because he was scared. I'll never forget that. What if Columbus hadn't sailed across the ocean? What if we hadn't lifted off Apollo 11? Where would we be today? I am strongly for this resolution and would encourage you to vote aye. Thank you.
Body, we've used proper names a couple times, so I'm just going to urge you to reorient to no more proper names. Representative Singh.
Thank you, Madam Chairman. So just before we continue, I just wanted to address a couple of thoughts. So the conversation about whether or not we know what's going to happen. Will there be any set of guidelines to a proposed convention of states? And I would suggest that we have precedent with existing conventions of when states meet together, that they are able to follow the rules and get along and conduct business with each other successfully, that we do have existing precedent for how something like this could be undertaken. One of the most famous of these convening of states that our great state participates in has to do with a river system which goes all the way to the ocean to the west of us. And those states are able to conduct business and fight for water, for a shared resource. So there is existing precedent for the states getting together and talking about particular issues. And I do agree that we should follow the Constitution, and the Constitution as written. And the process for amending the Constitution is written in the Constitution, in the Constitution itself, in Article 5. The founders, I don't think we're necessarily smarter than the founders, but we've been endowed with the same responsibilities as they have, and they gave us the tools to be able to amend that Constitution. Written in it, it was one of the only things in that convention that was passed unanimously. Think about the things that get passed unanimously in this House. They have to be pretty sound or pretty boring ideas for us to all get along with them. But this was one of the ideas in that convention that it passed unanimously because they saw the necessity of being able to amend this document. Some people call it a living document because it adapts with the needs of society. And so that's part of the merit of why I believe in this. I'm an advocate for federalism. I believe that we need to stand up for our own states, and that the necessity, or that the tendency is for the larger, more powerful government to take advantage of the smaller government. And guess what, guys? We are the smaller government in this situation. And so this particular resolution empowers us to take advantage of a system that was written in by the founders to adjust the rules that we have this power, it's written in, the previous power that we had to send senators to the capital of this country was taken away from the legislature, taking away part of that balance between the states and the nation. And so this resolution, in addition to addressing those outlying problems that are laid out in the resolution, in addition to that, it addresses one of the underlying problems that we have, which is the weakening of state authority in this country, this union of states. And so I just wanted to share that, and we can continue the conversation.
Representative Brady.
Thank you, Mr. Chairman. This is a constitutional process. A former president, so I don't mention his name, said, should the provisions of the Constitution here reviewed by be found not to secure the government and rights of the states against usurpations and abuses on the part of the United States, the final resort within the purview of the Constitution lies in an amendment of the Constitution according to the process applicable by the states. We all took an oath to uphold and defend the Constitution, which also means to follow it. We often point fingers at the federal government, how we perceive them to be acting outside constitutional boundaries. But we should be pointing fingers at ourselves because we, state legislators, are key to ensuring the federal government remains within its constitutional boundaries. We have clearly failed. It is our explicit duty and responsibility to restore the balance of power between the states and the federal government when that balance has been lost, which it has. The federal government isn't operating under the Constitution as originally written, but as interpreted by the Supreme Court, which has either intentionally or inadvertently distorted the meaning. For example, some decisions made in the 1930s granted power that allowed the federal government to spend and regulate on anything they want. With amendments, we can reassert the original limitations which have eroded over the decades. Just like the 14th Amendment overturned a terrible Supreme Court decision, we can do the same. There are questions about how or if amendments will work. We only have to look back in history to see that they do work, and we can go back at least 100 years. And we are following all of those amendments. We don't have slavery. I can vote. The president has 2 terms in office, etc. It would be pretty good to have fiscal responsibility for the last 100 years or even 50 years. There's nothing dangerous about proposing amendments. There have been over 10,000 amendment proposals, only 27 ratified. The founding era proposed and ratified amendments. The Constitution was ratified with only 7 articles. There were no amendments. No Bill of Rights. Article 5 was one of the 7. They intended we use it, as they did, to limit the federal power. Our country has gone off the rails. It is the state legislators who are authorized by Article 5 to restore constitutional restraints on our federal government. We cannot correct this by using the exact tool the founders put in the Constitution. Let's be a courageous, not a fearful body and engage in this constitutional process to restore our public. Thank you.
Representative Williams.
Thank you, Mr. Chairman. Remember, an Article 5 convention to propose amendments is not the same as a constitutional convention. At a constitutional convention, like we've heard in 1787, the states gathered pursuant to their reserved sovereignty and basic right of the people to alter their government, as recognized by their Declaration of Independence. But at an Article 5 convention, the states gather pursuant to their power and are limited by its provisions. The only power an Article 5 convention will have is the same power that Congress has every day in its session, the power to propose amendments. And that's only if they're ratified by 38 states. just like the 27 amendments we already have. Thank you.
Representative Closton.
Thank you, Mr. Chairman. Ladies and gentlemen, this is my third time voting on this. So my first time I voted yes. Second time I voted no. I learned a lot more about it. Now I'm voting yes. So one of the things I like about this is each state gets one vote, right? Wyoming is equal to, some of the larger states. So I appreciate that. People say, our Constitution's not broken. You're right. It's not broken. This is part of our Constitution. It's part of the rule book. You can't love our Constitution, but not this part of it, right? This is part of the Constitution. I always have a fear that at one point, one party will control the executive branch and then both houses. And I have a fear of them packing the court. I would like to see a constitutional amendment where we only get 9 Supreme Court justices, and they have age limits and they have term limits. This is the one way to do that. And for something to pass, you need both bodies of 38 states to approve whatever they come up with this convention. That is a very high bar to overcome. And I'm not sure it would actually ever happen, but I think what would happen is it would draw attention, the worldwide attention to what's going on at that convention. Can you imagine? We have a convention in states and we're talking about our debt or the Supreme Court or the federal overreach. Can you imagine the tension that would bring to some of the problems of this country that get ignored? Our national Congress would be forced to address some of these issues that we're all tired of. So again, on and for this. Thank you.
Representative Geringer.
Thank you, Mr. Chairman. I would completely agree. Our Constitution is not broken. It is not broken. But yet it does allow us to call this kind of convention per Article 5. What a perfect way to handle issues that come up like has been done over the last 27 amendments that have been done. These are ways that we can take into account issues that have arisen over time that weren't contemplated by our founding fathers. And I'm amazed at what kind of foresight they did have to be able to provide for all of these different things that we've had to deal with. And most times we can just refer right back to the Constitution and say, hey, this is good, this is not good. And yet they still provided us a way to be able to do something like this. It comes to a point where we have to ask ourselves, how do we fix the issues that we have? Do we let it, are we trying to tell Congress to fix these issues for us? No, that'd be like asking the barber if I need a haircut, for those of us that have hair. But the fact is, as has been mentioned, we're also talking about this. This is not going to get out of control. In fact, with 75% of states having to ratify this, can you imagine this body coming to a 75% agreement on everything, on issues that are controversial in particular? That's a steep hurdle to overcome. But we're never going to even try to get there if we don't pass this particular resolution. We need to have that discussion. We need to provide for fixing some of the mistakes that are being made in that city to the east of us that controls a whole lot. I've heard wisdom from my dad, my grandparents, that when you're in a hole, you need to stop digging. And I think we're in a hole, and we continue to dig. The federal government continues to dig that hole for us. We are $34 million or $1 trillion in debt. When do we start coming back from that? It keeps growing and growing and growing, and all we're going to do is sit around and say, hey, stop doing that. Please? No, really, please stop. We have to take the control back. We as individual states, we as the people, have to take control back. And this was provided for in our original Constitution. Thank you, Mr. Chairman.
Let's go Representative Chestick.
Thank you, Mr. Chairman. I will be brief. So there have been 37 amendments to the United States, 27 amendments to the United States Constitution so far. A little trivia question for you. How many of those 27 were approved by a convention of states? The answer is 0.
Representative Kelly.
Thank you, Mr. Chairman. I'd like to mention that I'll concede the point that no leadership body should ever make decisions based in fear. Of course, these decisions aren't as simple as learning to drive a truck or send a few people into space. We're talking about the lives of over 300 million people and leadership in the world generally. You can't overemphasize the size of this issue of what we're talking about here. So I want to mention something here because I have to refocus this, that we are aiming at the wrong target. And I give you the powers not delegated to the United States by the Constitution or prohibited by the states are reserved to the states respectively or to the people. Translation, if we didn't write it in this Constitution, the federal government cannot do it. And today the federal government does things that the founding fathers never would have dreamed of. Things that the empire from which they broke away probably would blush at. It's already in our Constitution that the government can't go outside these bounds. We already have a rule constraining the government from doing the things it's doing now, and it has been interpreted out of existence by some runaway judges, by some ideologues, by some activist judges. What would stop activist judges from today from immediately interpreting any new amendments out of existence and making them null and void as well? Again, we're shooting at the wrong target. There are people ignoring the rule book, so we want to add more rules for them to ignore. That's all we're going to do. We're not going to walk up to them and say, if we go up to them with the OGs of amendments, the Bill of Rights, and say, you can't violate these, and they laugh. Well, we got some new ones. Now you can't violate these. They'll laugh at that too. There are other ways to get the federal government under control other than just put up a larger 10th Amendment sign and hope they obey it now. Thank you.
I think that's the first time I've ever heard the term OGs used on this floor. Representative Pendergraft.
Thank you, Mr. Chairman. On and against. When I first got out of high school, my first profession was a mechanic. And pretty quick that I learned if you want to be a good mechanic, you have to be able to diagnose. Because if you start treating symptoms and fixing things down the line from what's really broken, all you do is waste your time because it's going to cause the problem again. And a lot of you at this point are thinking, oh, well, we got to fix the Constitution. No, the Constitution, as most people have said, isn't broken. So what's the real problem? The real problem is people that are not paying attention, people that are apathetic. But eventually, when things get bad enough, people start coming out of their apathy and letting their voices be heard. Now, I want you to take a look around this room. How many of us are freshmen? How many of us are sophomores? And I would submit to you that there's a reason for that. That a lot of people, and I'm not trying to discuss the relative merits of one position or another, I'm just simply saying a lot of people looked at what was happening here in this Capitol and said, I don't like it, I'm going to send somebody new. We folks are an example that term limits are not necessary. What is necessary is an educated, responsible voting public. And so what we need to be doing is to exposing what's going on, encouraging people to come out of their comatose lives and pay attention to the things that are affecting them. And we take care of that. The Constitution isn't the problem. The problem is people who ignore it. So if you change the Constitution, as the tall one from my county says. All you're doing is changing rules that don't get, bigger signs won't necessarily slow anybody down. I've said enough.
Let's go Representative Larson JT.
Thank you, Mr. Chairman. On and for this joint resolution. Members, if we don't pass this resolution, we become the problem. We are the ones that are standing between change at this point. It's not going to happen unless we stand up for what's right. And so, and on top of that, I want to, I think that a lot of us might not be here if it weren't for if the problems at the federal level weren't so huge. Because that's what I see a lot of us running on, is federal issues that need to be solved, and then we try to fix them at the state level and we can't. So we got to get our federal level under control, and this is the way we can do it. This is the way we can give our constituents the power to change the federal problems. On and for, I encourage and I vote.
Representative Singh.
Thank you, Mr. Chairman. Just a couple of points I wanted to address. So this convention of states, it would have a one state, one vote system. And so that is a significant benefit for our state specifically. Being the least populated state, our punches would hit heavier than any other state in proportion to one another. In order to attain the amount of states to ratify a proposed amendment to the Constitution, they would have to get past a whole legion of states that are collaborating on a same issue. So in order for anything to get passed at this convention, it would have to be something that states agree on. So one of the reasons why I ran for office was because I saw the legislature as an opportunity to be one of the most effective voices for my community in proportion to the amount of people that live there. Our races are smaller than some of the other county or municipal races that exist, and it was an opportunity to directly represent people on the issues that they cared about. And like the previous speaker had mentioned, a lot of the issues that our people care about the most are actually on the national scale. I'm sure so many of you have had conversations with your constituents, and they're concerned about something, but it's really something that has to do with the federal government and the failures on the federal government. I hear things, so much concern about the national debt. And this national debt that we have, it didn't come out of nowhere. It came out of bad precedent. It came out of practices being done on the Eastern Coast that our people simply didn't approve of. And this is the opportunity built into the Constitution to address those concerns from a state level. It gives the states the opportunity to check that federal power from the union. And these are issues that the legislative body over there simply will not take action on because it requires that they be held accountable. This is a built-in mechanism for our states to take a stand for what is a pressing matter to our people. And so, again, I urge and I vote.
Mr. Speaker Pro Tem.
Thank you, Mr. Chairman. So this is probably one of the most interesting conversations we're going to have this year as it bounces back and forth. And it's a dividing conversation because everyone has an opinion on this. Is Article 5 part of our Constitution? Absolutely. No doubt about it. And was it a mechanism that was placed there for correction? Absolutely. But I'm just going to give an example. The Article 1, Section 10, Clause 1 of the U.S. Constitution limits the ability to coin money and issue bills of credit. This means that
basically, no one shall create any bill or credit or make anything but gold and silver coin as tender of payments of debts. Well, I look here, and I won't hold it up because I can't use a prop, Mr. Chairman, but on this bill in front of me, it says this note is legal tender for all debts, public and private. And I ask the question, where's the point where we are already out of that constitutional line, among many others? And if we were to turn around and look at our good founding father, John Adams, when he says our Constitution was only made for a moral and religious people. It is wholly inadequate for the governments of any other. Morality and virtue are the foundations of our republic and necessary for society to be free. If we're being really honest, you guys, if we were to look at where our nation has come, we're no longer a moral and just people. And you may disagree, but if we were to take and ask those founding fathers, I would say that they would agree. And so we are at a point right now where the morality and justice of our nation is called into question. And so what we're going to do is this. We're going to take and we're going to bring people together to try to fix a document that honestly isn't broken. You know, if we were to go back and we were to look at some of the things that have happened in this nation over the last 5 years even, I don't know, and this is it, people can stand on either side of this conversation, but there's a lot in this room probably that would agree that in 2020, there were some nefarious things that maybe happened in an election and maybe someone didn't quite get in. Not because of the votes cast, but because of how the system was actually set up. So I would ask this question, if that is the case, then why are we standing here thinking that they would not go after the most sacred document this land has? Now, I would hope that if we were to see in Article 5, this convention, go forward, that we would see all the things we are hoping for. I would hope that. But the truth is, we have a track record. I have actual proof that says, you know what, if we're not a moral and just people, then how could we expect moral and just results out of this? You know, a part of me, and I'll be honest with you, there was a time in my life that I thought this was the answer. But the more I've looked at humanity, the more I realize that the moment we open our Constitution up to this scrutiny, we take the opportunity to have something happen that we do not intend. And again, everyone's passionate on both sides of this, and at the end of all this, we will agree to disagree. And probably in me speaking right now, I'm not changing anyone's mind. But I am saying this, if we're not careful, you guys, we could be responsible for undoing the greatest government that the nation, this world's ever seen. We are standing in a place right now, and right now on a screen in front of me, I'm looking at the longest standing government document in the history of mankind. And it stood the test of time. Why? Because we didn't mess with it. It stood the test of time. Why? Because we didn't make a mistake when we did. And there is a process right now to bring about that constitutional change. There already is a process, and it does not require us to open it up. So, you guys, I would just challenge you that we as a people need to make a very wise decision today about how we go forward with our Constitution.
Representative Smith.
Thank you, Mr. Chairman. Well, thank you from the last speaker, took away half of my notes. So I do agree wholeheartedly that our Constitution only works with a moral and just people, and we cannot legislate that. We need to attack it at the root cause, and we all probably have different opinions on how we can get our nation back on track. To address a few comments from before, there are only 2 things listed in the Constitution that the Convention of States cannot do. First is we cannot ban slavery before 1808, and the second is deprive the state's representation in the Senate, and that is it. So there's no further rules listed in any of our other founding documents, and there's no reason to believe that anyone will follow what our resolution says. So let's focus on morality and get our nation back to a moral and just people.
Representative Williams.
Thank you, Mr. Chairman. The problem today that we're facing is more complex than that our officials or our Congress are simply ignoring or disobeying the Constitution. The real issue is that certain provisions of our Constitution have been twisted from their original meaning and interpreted to mean something very different. Federal officials today follow the Constitution as interpreted by the highest court in the land. Consider the ACA that deals with affordable care. We know that nowhere in Article 1 of the Constitution, Congress has the power to force individuals to buy health insurance. The highest court in the land interprets that. And we know that that's not what was intended. The federal government doesn't ignore the Constitution. It takes advantage of loopholes created through practice and precedent. And the only real way to close these loopholes is through an Article 5 convention. And that will reinstate limitations on federal power and jurisdictions with our modern, clear language. Thank you.
Committee, before I go on to the next person, I'm just going to do a brief heads up here. We are on the last day of Committee of the Whole. This is the last day that you will see any of these bills come forward. We still have second and third reading starting next Monday and Tuesday. The only reason I'm bringing this forward to this body is a gentle nudge and a gentle reminder that if there is any vetoes that are passed forward after these bills move forward on second and third reading, while we are in session, he has 3 days to send those back to us. After those 3 days, we are no longer able to override those vetoes. So the more time we spend debating these individual bills, and I'm not telling you to not do that, I'm just giving a gentle nudge. The more time we spend doing this, the less time we have potentially able to override any vetoes that come to this body. So with that, Representative Schmidt.
Thank you, Mr. Chairman. I heard today that our Constitution isn't broken, and I agree with that. I heard today that our founders were a heck of a lot smarter than we were. I agree with that. In fact, they were so smart, they gave us this tool. They gave us this option. They were so smart that they knew these days we're experiencing and living in today would come. Now, we have to be smart enough to use the tool they gave us. On and for this resolution. Thank you.
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. I'm a little bit of a history nut. I've studied some ancient history and some of the empires that have risen and fallen over the centuries. And as you study how they came to power, I also studied how they declined in power. And they declined because they started to change their form of government. That's when they started to decline. We became one of the greatest powers on earth 200 years ago when our Constitution was written. I don't necessarily think the people that wrote our Constitution are any smarter than we are. I believe they were inspired of God. I believe our Constitution came from God, not from men. And it was given to us, but if we start changing it, I think we're going to lose some power, and we're going to lose our form of government eventually, and we're going to be on the decline, just like these great empires in the past. Now, I want to make this really fast, but because we got a lot of work to do, Mr. Chairman, and I got a lot of push to bring this to the floor, knowing that it was going to take some time. But when we first met 7 weeks ago, remember what some of the first things we did as a body? We wrote our rules for this 68th legislature, and we set our agenda. If we call a constitutional convention, what's the first thing they're going to do? They're going to write their rules for the constitutional convention. I've heard here just this past hour, we need a constitutional convention because of a need for term limits and a balanced budget. But during the past hour, I have heard multiple other things that need to be changed. How do you think they're going to get together in a constitutional convention and just deal with two issues? I do not believe that will happen because in this little body right here, we've already heard a number of other issues that needs to be fixed. That will happen also. And I strongly believe our Constitution was inspired from God, and it was given to us for the greatest empire on earth in Earth's history, and I do not want to change that. Thank you, Mr. Chairman.
Representative Lean.
Thank you, Mr. Chairman. In 1988, in the highest court in the land, a Chief Justice once wrote, "There is no way to effectively limit or muzzle the actions of a constitutional convention. The convention could make its own rules and set its own agenda. Congress may try to limit the convention to one amendment or one issue, but there is no way to assure the convention would obey." Some wise words came from 1798. Where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. That same founding father said, "Whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force." I echo the concerns of a concerned constituent that in our polarized times, the convention may become a battleground for extremist, special interest, or those that are looking to change the Constitution, risking changes that undermine the liberties that we hold dear. The Bill of Rights and this piece of legislation claim to protect what could be gutted, not because anyone intends it, but because nothing in Article 5 prevents it. I stand before you today in opposition of this because I too trust the founding fathers and the great Constitution that I swore an oath to in this office on and against this bill.
Representative Brady.
Thank you, Chairman. Just as a reminder here, we're not speaking of a constitutional convention. We are speaking of a convention of states. And I agree with the legislator earlier, the Constitution isn't the problem. And again, I agree. But I'll also say the Constitution is the answer. 10th Amendment issue, I agree that we have our states' rights, but the federal government is tyrannical at this point. So what I'm saying is, another point about being, talking about the money and being trillions, 34 trillions in debt and chaos everywhere. But then again, you say our government is the greatest government in the world has ever seen. Then state what dire straits we are in, and then still be able to claim we can't have both sides of this. And you say it's a godless, immoral, and unjust society. Why can you, any of you, are you going to raise your hand if I claim that every one of you in here are unjust, immoral, godless? And you said they go after the Constitution. Who is they? We the people? I stand on this. Esther 4:14, perhaps you were born for such a time as this. I'm for the...
Representative Geringer.
Thank you, Mr. Chairman. I really do enjoy this form of government that we have, that we're able to stand up here and we're able to debate, we're able to have these discussions about things that truly do impact our state and our country. This is fantastic. We heard at one point that writing new rules won't change anything, and I guess I'd submit to you that if writing new rules doesn't change anything, we wouldn't have a constitution in the first place. We wrote new rules. Our founding fathers wrote new rules. We overthrew a form of government that we didn't agree with. And I'm not suggesting that we overthrow this government. I'm suggesting that we write the rules that enable us to take power back from an overbearing federal government. We also heard that there's other issues with the Constitution, that we don't follow the rules right now. And I guess I would submit to you on that maybe it's time that we as states assert our power as states to take care of these issues. Because it is our form of government. This is not redoing our form of government. This is exercising the powers enumerated to us as states to protect our form of government. So I would ask you also to make a wise decision today and consider what we do. What do we do? How do we fight back? We've heard that there are other ways to do that, but we're not finding the solutions. If we keep on the path that we're on, we have not found any solutions to this point. We keep digging that hole. On and for.
Chairman Locke.
Thank you, Mr. Chairman. On and against this bill, and I strongly urge everybody to vote against this. The truth is, the previous speaker said it, we have the capability to make a difference. We absolutely do. We have the ability to push back on the federal government right now. We have the ability to really strongly take a position on the sovereignty of our state, and it's got nothing to do with the Convention of States. Let's do that first. Let's take back our state sovereignty with the tools we already have in our toolbox. Quit thinking that if we reach out there, somehow magic's going to happen. That's not going to happen. Okay, we're going to take back the sovereignty of our state right here in this room by telling the federal government where they are breaking those laws, where they are overstretching those boundaries. No, that's the answer. Please vote no on this amendment, or on this bill.
Speaker Nyman.
Thank you, Mr. Chairman. Listening to all this debate, and I've never heard anything really mentioned to this point about this, and in my conversations with some of the folks that are really pushing this on a national level, I went down and listened to them. They were here earlier, got an opportunity to listen to some of their talking points. And you're talking about a balanced budget. You want to go back and you want to curb spending on this federal government. Well, guess what, ladies and gentlemen? Stop taking the money. It is within our power and our reach to quit allowing the federal government to drag us along as states when they dangle money in front of us all the time. How are you going to get 38 states to agree to quit taking subsidies, ag subsidies, other subsidies? We can do it right now. It was clearly enumerated. Everybody here has said we have the right to be able to stand on our own. All those powers that are not clearly enumerated are the responsibility of the states. The control that they have over us is money and our incessant desire to continue to consume it. And with that consumption of them dollars, ladies and gentlemen, comes the control of the federal government that we willingly give them in exchange for the dollar. With the shekels come the shackles, ladies and gentlemen. We can stand up here and bloviate all day long about how this is going to change. And unless you change the appetite of the people of the United States of America and stop having to rely on federal funds and seek those funds, this is not going to change. A balanced budget, in my mind, is truly out of our reach because we cannot get shook free of those dollars that they dangle in front of our faces to keep us under their thumb. And until we can control our spending, we best be for leaving that document alone. Because until we control that spending, we don't want things to change. We're glad to take the money. The money is the controlling mechanism in this, ladies and gentlemen. That's how they've done it. That's how we're generating $1 trillion every 90 days. It's because we can't control our spending. Our addiction to federal money. That's what ties us up. If we can break free of that, we don't need it. On and against the bill.
Representative Hirschman.
Thank you, Mr. Chairman. Just the context of history is really important. World War I, World War II, massive federal debts. Paid all that off. Never incurred debt. Since the 40th president, debt is basically doubling every president. And I don't think it's us taking the money or anything else. It's the appropriators in Washington, D.C. So on and for the amendment. Thank you.
Representative Singh.
Thank you, Mr. Chairman. Just wanted to land the plane here, folks. Thank you for this thoughtful discussion, and I really do appreciate everyone sharing their opinions on this. This is a contentious issue. And so just to close this off, we bring this bill in an effort to strengthen the position of the states, to give them an outlet for them to express their concerns with the Constitution in an organized manner, which is described in the Constitution itself. We talk about the rights that are delegated to the states that can't be impeded upon by the government. That particular language had to be amended into the Constitution. That itself was a change that had to be made in the Constitution. And so the mechanisms to change, if we identify problems in our system of government, particularly problems where the states themselves are disenfranchised, the lesser populated states themselves are disenfranchised, we have the opportunity here with this resolution to give the smaller states and the states apart from the federal system, that was the them that was being referenced earlier, the federal government versus the states. And this gives the states the opportunity to have their say as an additional check in our system of government. And I believe that was a feature from the get-go. It was written right in. And when we changed the Constitution was changed in the past to take power away from the states. And from that point, the states have not had the opportunity to express themselves like they did in the past when the legislature was the one to send a senator to our capital. And so that is really the spirit of this resolution, to ensure that Wyoming has a voice and is able to bring themselves to the table when this table comes about. And this is not isolated to Wyoming. There are states all across the country that want these particular issues to be talked about. We are not doing this in isolation. And so I'm asking for your aye vote. Thank you, Mr. Chairman.
Question being called. All those in favor of Chairman Andrews' motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate Joint Resolution 1 do pass, please signify by saying aye. Aye. All those opposed, no. No. The chair will make a call before division is called. Thank you. Having failed a voice vote, a standing division vote is required. All those in favor of Senate Joint Resolution 1, please rise. Please take a seat. All those opposed, please rise. You may be seated. Having failed a standing division vote, according to Rule 6-6B, a roll call vote is required. Chief Clerk, when you are ready, please call the roll. Representative Wiley, can I have you come to the dais, please?
Alamand? No. Andrew? Angelos? Banks? Bear? No. Brady? Bratton? No. Brown Gary? No. Brown Landon? Byron? No. Campbell Elisa? No. Campbell Kevin? Chestick? No. Clouston? Connolly? Repeat? No. Davis? Aye. Eklund. Erickson. Feiler. Geringer. Guggenmoss. Haroldson. Harshman. Heiner. Heft. Jarvis. Johnson. Kelly. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas, excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Webb. Weber. Worf. Williams. Winter, excused. Wiley. Yin. Mr. Speaker, are there any changes? Jarvis, no. To aye. Further changes. Further changes. Closing vote. Vote closed. 25 aye, 32 no, 5 excused.
Having failed a roll call vote, Senate Joint Resolution 1 is indefinitely postponed. Mr. Majority Floor Leader.
Mr. Chairman, thank you. I move that the Committee of the Whole rise to sit again in order to do some concurrences and enrolled acts.
You've all heard the motion. Please signify by saying aye. All those opposed, no. Mr. Speaker.
We are at that, excuse me. We are at that order of business of signing of enrolled acts. First enrolled act for our consideration is House Enrolled Act number 54.
House Enrolled Act number 54, being original House Bill 90, an act relating to agriculture, livestock, and other animals, requiring the Livestock Board to develop a protocol for positive anthrax tests, requiring rulemaking, requiring a report, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act number 54, having been original House Bill 90. I have so signed. Congratulations, Representative Davis. Next enrolled act for our consideration, House Enrolled Act number 55.
House Enrolled Act number 55, being original House Bill 79, an act relating to elections, requiring a minimum threshold of ballots cast in a bond election held on any day other than a general election as specified, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act number 55, having been original House Bill number 79. I have so signed. Congratulations, Representative Stargard. Next, we have Senate Enrolled Act number 61.
Senate Enrolled Act number 61, being original Senate File 103, an act relating to the administration of government, generally prohibiting diversity, equity, and inclusion efforts and mandates by states, agencies, and public educational institutions, conditioning the expenditure of appropriated funds as specified, specifying applicability, providing an appropriation, and providing for an effective date being enacted by the legislature of the state of Wyoming.
I am about to sign Enrolled Act number 61, having been originally Senate File 103. I have so signed. We have a message from the governor. Please, reading clerk.
February 28th, 2025, to the Honorable Chip Nyman, Speaker of the House. Regarding no signature of House Enrolled Act 33 being original House Bill 116, driver's licenses, unauthorized alien restrictions, suspend further reading. Sincerely, Mark Gordon, Governor.
Moving on to, we are at that order of business to a request to concur with the Senate amendments to House bills. First message for our consideration is message number 416 in regards to House Bill 154. Representative Knapp. Whenever you're ready, good sir.
Mr. Chairman, I move message 416 for House Bill 154 and ask for a no vote on concurrence. Getting this back from the other body, we received an amendment in there that basically took the authority to investigate away from both the county clerk and the secretary of state. So within this bill, there's no mechanism to investigate a false voting. And so with that, we would ask for a no vote.
Any discussion? Question? Okay, ladies and gentlemen, we will be working to create a conference committee that will be Clouston chairing, Yin, and what? Huh? Oh, to not concur? Okay, okay. So we do need to do that. Okay, if we don't, okay. So we are voting on a motion to concur with Senate amendments to House Bill 154. A majority of the elected members is required. The chief clerk will call the roll.
Alamand? Andrew? Angelos? Banks? Bear? Brady? Bratton? Brown Gary? Brown Landon? Byron? Campbell Elisa? Campbell Kevin? Chestick? Clouston? Connolly? Davis? Eklund? Erickson? Filer? Geringer? Guggenmoss? Harrelson? Harshman? Heiner? Heft? Jarvis? Johnson? Kelly? Knapp? Larson Lloyd? Larson JT? Lawley? Lean? Locke? Lucas? McCann? Nicholas, excused. Ottman? Pendergraft? Posey? Provenza? Riggins? Rodriguez Williams? Schmid? Sherwood? Singh? Smith? Storer? Strock? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber? Wharf? Williams? Winter, excused. Wiley? Yin? Mr. Speaker, are there any changes? Are there any changes? Closing vote. Vote closed. 1 aye, 57 no, 4 excused.
By your vote, you have voted to not concur with Senate amendments to House Bill 154. The committee will be assigning to go, I tried to do a little earlier there, Clouston, Chair, Yin, and Locke will be our committee to go down and represent the House position on that. Next message for our consideration is message number 415 in regards to House Bill 117. Representative Banks, please proceed.
Thank you, Mr. Speaker. So I move message number 415 to concurrence on House Bill 117, the Omnibus Water Bill Construction, and ask for an aye vote on concurrence. Now, if you look at all of these amendments, it looks like a lot, so I'll just try and go through them here. So what they did in the First Amendment was, if you recall, this body added the ability for wells to be developed over in the LaPrelle area, and that the body across the hall took that out. And after being in consultation with those in that area, the legislators in that area, they deemed that to be okay at this point. And then the Second Amendment is basically transferring accounts and funding. So if you recall, money was taken from the Alkali Creek project, given to the LaPrelle project. The other body decided to fund both projects, so LaPrelle and Alkali Creek will now both be funded. The one that is probably most on the minds of this body is they decided that instead of doing all the cloud seeding, so we took it out, they put ground-based cloud seeding back into it, but left the aerial cloud seeding out of it. Whether you feel on that one, as it was a kind of a meet in the middle there. The next amendments were, again, things that were in the budget and that need to be included on there, so that we put, the other body put a position in the state engineer's office with a board of control, as well as an appropriation to the state engineer's office that calculates the natural flow of the North Platte River. If you recall, both of those were included in the budget, and necessary positions and necessary appropriations dealing with water. There's also at the end an amendment that gives the direction to the Office of State Lands and Investments to investigate opportunities working with the Board of Land Commissioners with exchanges of public lands and private lands around the LaPrelle Dam area. So those were the big changes to the bill. Had some consultation with the other body and with members of this body, especially those on select water, and feel at this point we concur with the Senate. So asking aye on concurrence. Thank you. And
Chairman,
take any questions.
Chairman Washington. Thank you, Mr. Speaker. So what's the price tag on the two dam projects?
Representative Smith. Yeah, Representative Schmidt, please.
Thank you, Mr. Speaker. I would ask the chamber to vote for against concurrence, simply for the standing amendment number 1, third reading to reinstall the cloud seeding. We as a chamber voted against that. I would like the opportunity to discuss that option further. The rest of the bill is fine, but this is an option we took out. It's about our landscapes. It's about our mountains. It's about our country. It's about our state. I just ask for a no vote on concurrence and give us a chance to talk in conference a little bit further on this topic. Thank you.
Thank you, Representative. Representative Bear, first time.
Thank you, Mr. Speaker. I too would encourage a no vote, and I would say that the rest of the bill is not fine. This LaPrelle Dam, there was a question earlier from the good chair of committee number 1, and it's $50 million is what the transfer from the Alkali Dam was coming in to apply to the LaPrelle Dam, which is an immediate need. The issue with the Alkali Dam, and we received quite a bit of testimony in our committee, the Alkali Dam is waiting to get easements. And so they're still working that out. They're a long ways from spending money on that particular project. So to put our money to good use was to take that money out of that project, put it over here where we're going to use it immediately. And the bill was written such that as money came in, it would be removed from that project as it was available and put back to the Alkali. So we have a mechanism to make sure that both projects are funded, but let's not waste the money while we're trying to get these projects done quickly. The one project is not ready for this kind of funding. So that was 50 million is the answer. And if we do what the body down the hall suggests, we're looking at that 50 million hitting our bottom line immediately and just sitting out there waiting for that project.
Representative Larson, JT.
Thank you, Mr. Speaker. On and in favor of concurrence. Members on the cloud seeding portion, the body down the hall, they made it where there's no state dollars, as I understand, no state dollars will actually go into the cloud seeding program up to this point now. It'll be all privately or other states funding that. So I encourage and I vote on concurrence for that reason. Also, the dollars that are set aside for Alkali Creek in the position that the other body had, it's just an earmark. It's not actually spending those dollars. So just want to put that out there as well. So on and for concurrence.
Representative Yen, first time.
Mr. Speaker, thank you. So I also urge concurrence. What the Good Appropriations Chair is correct, it is 15 more million out of LISRA. But the money, I mean, if the Alkali Creek project isn't being built anyways, that money is still not going to be spent. So we're not losing any money. All we're doing is still keeping the earmark for the Alkali Creek project, that we still want to have that position, that we still want to support it being built. I think that was the concern over in the other chamber ultimately, that we didn't want to make it seem like we've given up on Alkali Creek, where the people that oppose Alkali Creek in that area just wanted to create a situation where they point to the state and say, look, the state doesn't support this anymore, let's just kill this project and never go on any longer. They can just force it to close that way. The cloud seeding one, again, want to reiterate, we took out all the funding for cloud seeding. They put in the ground seeding project, but they made it so everyone else had to pay for it and there would be no state dollars. You can see on the third page of the concurrence report, 100% of actual project costs must be paid from other basin water users or other interested parties. So no taxpayer dollars. And then two, the last thing I want to point out is the second to last thing I want to point out is that the recreational opportunity is still in there, but it's split out of the project. So that way we don't consider it as making that money depend on the recreational opportunity. We've put it out in this section 5, or they put it out in this section 5, where we've tasked the state lands to find opportunity for those recreational opportunities. And I will say there's been an update since it left this body and went over to the other body. They actually talked with the folks that own a majority of that land around the reservoir, and there seems to be a positive response of trying to make those land exchanges to make those recreational opportunities available. So we could even see a new state park in our future there if we adopt this. And then the last thing I want to bring up is that we are ticking down the days. This is a bill that there is line item veto authority by the chief executive. If we want to get this out the door fast enough for us to override any vetoes it is very important for us to move this forward. And that is probably the biggest reason I'll urge for your concurrence, just so we can get this bill signed by both of our bodies, get it down to the chief executive, and if there are any vetoes, we will have the time to override them. And so with that, I ask for your aye vote on concurrence. Thank you, Mr. Speaker.
Thank you, Representative. Representative Straub for your first time.
Thank you, Speaker. And I will tell you, we spent quite a bit of time talking about there were a couple things that were kind of a worry to, could be a concern. We were going to go look for different options of water, being able to do some irrigation. I went ahead and said I would rather see this bill get over the finish line before we leave, so when I go home, we know that there is money available to rebuild the dam. So I would like to concur if, before that reason. I don't want to sit there and head home and have no idea if there's going to be water for the dams. So and the other thing on that last bit of paragraph, I understand how a lot of you want a recreation there. And if it works, that's great. And I'm glad they put in there that there's going to be studies and they're going to really look into it. But so I would ask for an aye on this concurrence.
Thank you, members. Any others for their first time? Seeing none, second time? Oh, first time? Representative Brady, first time.
Thank you, Mr. Chairman. On this water bill, I would say, I know there's little pieces here and there. If there's even one that even one of our representatives is concerned about, and I am as well, we should unite and stand together, and I say no on the whole thing and don't concur.
Any other representatives for their first time? First time? Seeing none, second time? Second time, Representative Schmidt.
Thank you, Mr. Speaker. Just to be clear, the funding that was mentioned about the cloud seeding, I just want everybody to know that's not secured. That is something that they're going to make an effort to do. Please keep that in mind.
Thank you, Representative. Any other members for second time? Hearing none. Back to the bringer. Representative Banks.
Thank you, Mr. Speaker. All valid concerns. I think top of the concern list is what the good minority leader said, the ability to override those line item vetoes. We're up against the deadline, and I think in order to get the projects that this body is going to benefit from, our communities are going to benefit from, we got to get this across the finish line. There was some compromise with the other body, and I think that it's going to be in our best interest to get this to where the legislature has the control of our water projects. We don't cede that power to the chief executive, so on and for concurrence.
Question being called. Body, we are voting on the motion to concur with Senate amendments to House Bill 117. A majority of the elected members is required. The chief clerk will please call the roll.
Allemand? Andrew? Angelos? Banks? Bear? Brady? Bratton? Brown, Gary? Brown, Landon? Byron? Campbell, Elisa? Campbell, Kevin? Chestick? Clouston? Connolly? Davis? Eklund? Erickson? Filer? Geringer? Geringer? Guggenmoss? Haroldson? Harshman? Heiner? Heft? Jarvis? Johnson? Johnson? Kelly? Knapp? Knapp? Larson Lloyd? Larson JT? Lawley? Lean? Locke? Lucas? McCann? Nicholas, excused. Ottman? Pendergraft? Posey? Provenza? Riggins? Rodriguez-Williams? Schmid? Sherwood? Singh? Smith? Storer? Strock? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber? Worf? Williams? Winter, excused. Wiley? Yin? Mr. Speaker? Are there any changes? Filer, excused to aye. Bratton, aye to no. Further changes? Closing vote. Vote closed. 34 aye, 26 no, 2 excused.
By your vote, you have chosen to concur with Senate amendments to House Bill 117. Messages from the Senate.
Message number 422. Mr. Speaker, Senate File 40, zoning protest petition amendments. The Senate failed to recede from non-concurrence on House amendments to the bill listed above by the vote indicated. Ayes 8, noes 23. Message 421. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 152, Wildfire Management Task Force and State Forester. Ayes 26, noes 5. Sincerely, Ellen Thompson, Senate Chief Clerk.
Okay, Representative Brown, I do believe that's it. We can go back to Cal. Oh, Representative Provenza, please.
Privilege of the floor, Mr. Speaker.
By all means, proceed.
Thank you. Hopefully, everybody had a chance to make it in, but I would like us all to please welcome our constituents from every corner of the state. These folks represent the skilled trades, teachers, state and federal workers, miners, electricians, pipe fitters, baristas, and more. We serve them every day. Please give them a warm Wyoming welcome and thank them for everything that they do to drive our economy and our communities.
Welcome to the House. You are Wyoming, and you're what drives this economy, and you're what provides the things that we need and get the job done. We appreciate you, and we are so thankful for what you do and the sacrifices you do, and you get up every day and you hit it head on, and that's what we need. And we continue to hope that you will continue to stay here in our state, and we're going to do everything we can to try to make sure that happens. So thank you. Glad to have you in the House, and welcome, always. Representative Brown.
Committee of the Whole, please come back to order. And I'm actually going to make sure that we've got the next bill here. The next bill for our consideration is Senate File 34. Reading clerk, please read the bill.
Senate File 34 is sponsored by School Facilities, School Finance, Routine and Major Maintenance Calculations, an act relating to K through 12 public school finance. Mr. Speaker, your committee number 2 appropriations, to whom is referred Senate File 34 engrossed. School Finance, Routine and Major Maintenance Calculations. Respectfully report, same back to the House with the recommendation that do pass. Ayes, Representatives Alaman, Angelos, Harrelson, Pendergraft, Sherwood. Noes, Representatives Baer and Smith. Representative Baer, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Baer?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 34 do pass, and I'll pass the explanation over to the good chair of Transportation.
Chairman Brown.
Thank you, Mr. Chairman. Ladies and gentlemen, it's kind of a complicated bill, but I'm going to try to make it as easy as possible, and I'll stand for questions. So what I want to tell you is when we build schools now, we build them to a certain model. And that model says, hey, every student is awarded, we'll call that, or given a certain amount of space. Well, prior to the state taking over school buildings and going through this process, we had a lot of schools built across the state. One of those is up in Camel Country, right? And we've got an area up there where you've got some excess square footage. And why does it matter if we have excess square footage? Well, if we only pay out on the amount that a student is deemed necessary for equitable learning space, and they have excess square footage, they're not getting major maintenance funding to take care of that particular area, right? And so what you've got right now across the state is about a $38 million shortfall on major maintenance funding on these schools. And that comes from a culmination of years and years and years of building these schools and allowing the communities to build these schools to their standards before, again, the state took over. And also, when we started building the schools, they were built to a different standard than what we have currently. So this bill is trying to rectify that. This has honestly been a bill that has really been the essence of about 6 years worth of hard work. And so what you have in front of you, Senate File 34, is updating our language. And we went through about 6 different ways of how we could attack this. And this seems to be the easiest way. And so what we're currently doing right now is we funded 115% of allowable square footage for school districts. Well, that means that if you have more than 15% over the allowable square footage, you're still being shortchanged. So this bill is correcting that by taking this up to 35 or 135% of allowable square footage and rectifies that issue. We're still shortchanging ever so slightly, but those schools that we're shortchanging are going to be the ones that we're going to start seeing come off the list, and we're going to start seeing rebuilt over the course of the next few years. The other thing that this bill does is it does change the multiplier. And the multiplier is basically how we, if you look on page 5, we get rid of the language that was back to 2%, and we keep it at 2.5% on the multiplier. And that is really basically our cost measuring. How do we ensure that the money that we're sending out to these districts matches exactly what they need to see in their school districts? So I'm looking at the time, it's 4:45, everybody's eyes are glossed over, and nobody's coming up to the mic to talk about school finance and school facilities finance. So that is in essence the bill. This bill does have that $38 million appropriation. The appropriation will get divvied out to the school districts proportionately and based off of their square footage and allowable square footage. And with that, I finally see somebody who wants to talk school facilities.
Representative Haraldson.
Thank you, Mr. Chairman. So when we heard this bill, a couple things just to keep in mind, and I think this is probably a down the road conversation, but currently there's obviously a big difference between routine maintenance and major maintenance. And so major maintenance and that calculator on square footage being used or allocated is completely different than routine maintenance. And because at that point, I mean, I think it's kind of a bit of a miscue that we are using this calculator for routine maintenance, because the reality is you got to maintain the entire building. But as this is going from the 115 to the 135 does help that. But I think down the road, we probably have to have a conversation about major maintenance and routine maintenance. Because in the major maintenance realm, absolutely, the number of students, 90%, that all that calculates in. But when it comes to the routine maintenance, we have the responsibility, I feel, to maintain these buildings at 100%. And that's a conversation that we'll have to have down the road. But I do believe this is a step in the right direction. And also, just for the clarification, that funding is not a general fund appropriation. That is a school foundation program account appropriation, just that will then slide over. So just something to keep in mind.
Chairman Brown.
Thank you, Mr. Chairman. And one other thing that I did forget to mention that I think is very important is some of our communities have actually lost a lot of students, especially over the course of the past 10 years. Our actual trend line for students in enrollment is on a downward trend across the state. And so what does that mean? Well, when we actually have a trend line downwards, that means we have schools, let's just use round numbers, we have schools built for 100 students, but now we only have 90 students in there. And so what happens is we've built this school for 100 students. Just because you only have 90 students doesn't mean you shouldn't take care of the whole school. And so that's another portion of what this bill is trying to correct as well. Again, I don't disagree with the Speaker Pro Tem on this. This is not necessarily a Band-Aid. I think we're doing some good work with this and good movement in the right direction. However, it is still slightly underfunding our major maintenance calculations. But what I will also say is the major maintenance issue that actually the good bear from the Lander area is getting ready to talk on, we actually addressed the major maintenance issue statewide last year as well. And so we actually have a fix coming forward, and some of that stuff will be fixed as well. So on and for.
Representative Larson Lloyd.
Thank you, and just would like a reminder or re-education, if you would, on that 2% and 2.5%. That's of the replacement value of the asset, if I'm not mistaken. And then can you also, as we talk about that major maintenance and what all it covers, that it seemed like there was a nuance there on parking lots and enhancements that may not or does that cover. So just clarify that up so that we kind of have a little better understanding of what all how thin we have to spread the butter across the bread.
Chairman Brown.
Mr. Speaker, that is exactly correct. To the good former Vice Chair of Appropriations, that's exactly the 2.5% is the replacement cost. The other thing that I will say is there is a lot of nuance in major maintenance, right? I think that's probably one of the larger discussions that not only this body has had just in the past couple of years, but over the past 10, 15, 20 years. So there is discussion on, can this be used for enhancements? And the answer is yes. So they can use this on enhancements. However, when they do major maintenance, ladies and gentlemen, all of these projects are actually put into what they call an AIM system. And that system tracks every single program. They're given this information to the school district. And when the school district puts it in there, it tracks and says, hey, look, this project was completed with major maintenance funds. So there's still some gray area on people that attempt to try to maybe push some of this money aside and use it in different areas. But I think the bill that we actually passed last year cleans that up a whole bunch as well. So any further questions, Mr. Chairman?
Further discussion? Question being called. All those in favor of Chairman Bear's motion that when the committee of the whole rises to report, does so with the recommendation that Senate File 34 do pass. All those in favor, please say aye. Aye. Opposed, no. Next bill for our, Senate File 34 has passed committee of the whole. Okay. Yep, okay. All those in favor, please stand. All right, you may be seated. All those opposed, please. All right, Senate File 34 has passed committee of the whole 32-25. The next bill for our consideration is Senate File 91. The reading clerk will read the bill.
Senate File 91, sponsored by Select Tribal, Petroglyph, Pictograph, and Historic Inscription Protection, an act relating to crimes and offenses in state lands. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 91 engrossed, Petroglyph, Pictograph, and Historic Inscription Protection, respectfully report same back to the House with the recommendation to pass with the following amendments. Ayes. Representatives Byron, Campbell, Connolly, Harshman, Jarvis, Provenza, Storer, Thayer, Wharf. Representative Byron, Chairman.
For the reading of the bill, what is your pleasure, Chairman Byron?
I move that when the committee of the whole rises to report it, do so with the recommendation that Senate File number 91 do pass, and I further move the adoption of the Standing Committee Amendment. And for the explanation of the Standing Committee Amendment, I will walk you through it. Folks, This bill came from down the hall, made it over here, and got resurrected just a few days ago. And part of that was trying to figure out with what's been going on in terms of our budgeting process, how this looks. So I decided in committee and in talking with a lot of folks that are involved in the department that's affected by this to go ahead and remove the appropriation. So this removes the appropriation of $441,340, and it cleans up some of the language that appropriation was going to go to, specifically on, if you happen to be looking at the amendment, changes some different words, effective dates, and basically cleans up what that appropriation did. With that, the appropriation, by removing that, also took away the effective date. So on that amendment, if you're looking at it, page or line 24, page 1, it inserts the new effective date that it's effective immediately should it pass through this body. So with that, I will happy to answer any questions on the amendment.
Representative Larson on the amendment.
So if the good chairman would help me understand, I think the intent of this bill is to preserve those petroglyphs and other rock inscriptions, and this funding was to help identify, map, and put into place how we do that. So if that's accurate, how do we get that done without an appropriation? And if I'm wrong, tell me what the intent of the bill then is without the appropriation.
Chairman Byron.
Thank you, Mr. Chairman. That is partially correct. The bill also adds a penalty and it actually increases the penalty, which we'll get to here in a moment. But on the amendment, you do bring up a good, the good representative from towards the northwest corner does bring up a good point. And it is something that we battled with. The department that this bill affects that would do that work was comfortable with at this time removing that appropriation. Certainly would look forward to a conversation should this body want to discuss that at a later reading. But at this time, on the amendment, it was the way we could continue moving this bill forward and getting in statute the framework to do what the good presenter will soon present us with.
On the amendment, Representative Worf.
Thank you, Mr. Chairman. I would also add to that, one of the things, we can start doing some prep work now. We've got a year before the general budget or the budget session comes up, and we'll have opportunity to fund that at a later time. So that's really why we felt it was more important to get the bill through than to worry about the funding. It can be picked up at a later date.
Any further discussion on the amendment? Seeing none, question being called. All those in favor of Standing Committee Amendment number 1 to Senate File 91, please signify by saying aye. All those opposed, no. Standing Committee Amendment number 1 has been adopted. We are back on the bill. Representative Chestick.
Thank you, Mr. Chairman. I was a member of the interim select Tribal Relations Interim Committee last summer when we studied this issue. I think I'm the only remaining House member that's still here who was a member of that committee. At one of our meetings, we took a tour of a site near the reservation. I'm not going to say where it is because these sites are sometimes not publicly known, to basically to protect them from vandalism. But it was near the reservation. It was full of all kinds of petroglyphs and pictograms, ancient, some within 1,000 years, some older than that. And they are suffering. They are from two sources. One is weathering, but the immediate source that that the remaining part of this bill does address is vandalism. People using those for target practice. People trying to carve their own initials or deface them in some way. We saw one beautiful pictograph, it was a petroglyph, I guess, where somebody actually took a concrete saw and was trying to carve around the edges of it to hopefully, I think they were going to plan to remove it somehow and take it off the rock. We looked at the existing statutes and couldn't really find a lot of remedies for that kind of situation. So the Tribal Relations Committee proposed, what is on page 2 of the bill, is the main part of it, from lines 9 to 15, creates a new misdemeanor felony with a penalty to help protect against vandalism and other attempts to steal or otherwise deface these very valuable markings. So for that is the explanation of the bill, and I would ask for an aye vote.
Representative Campbell.
Thank you, Mr. Chair. So sitting on that committee, we heard from both, I mean, our state lands and our state parks, the importance of doing this, not only to document what is out there so we get kind of a baseline, but also to have that ability to prioritize where do we need to have protection and how do we educate the public as to the history and the really cool things going on in our state. And from the state lands, they said, we really need to know where these things are so we don't inadvertently grant a permit to develop land and do damage. So it's really important that we understand where these are and, you know, how do we best protect them and preserve them without accidentally doing damage. So both sides said, absolutely, this is something we need to move on. So removing that appropriation allows us to do that. We can move forward on this and then address the needs in terms of both sides when the budget cycle comes around. So important for both sides of the equation that we get this in place.
Representative Lean.
Thank you, Mr. Chairman. While I support page 2, lines 9 to 16, my question comes on page 3, lines 2 to 4, where it talks about a survey can't be conducted without first notifying or consulting the landowner, but it doesn't say that they have to give you permission to be there. So my concern is, are we somehow injuncting eminent domain to be able to preserve this history?
Chairman Byron.
Thank you, Mr. Chairman. I'll take a swing at that. I don't read it that way. Page 3, line 2, said, no survey conducted pursuant to this section shall access private lands without first notifying and consulting with the landowner. So certainly would entertain a later reading amendment if that's really a worry, but the intent is this, that these exist not only mostly on what we heard was state lands, but not really wanting to necessarily be very public at where these are, to the good gentleman from, the good representative from over the hill, because these are such sensitive sites, and yes, a lot of them probably do exist on private land, but at this time, the intent, and I was not on the committee, but the intent is to notify that landowner and consult with that landowner. So I am not worried about that. If there's worried from the body, I'd certainly work with somebody on an amendment if we see fit.
Representative Larson.
Thank you. To the members of the committee, when you was talking about this, I'm still lamenting a little bit that we took out the funding for this, and I get that, but so was there conversation, and did the agency that deals with cultural resources talk about, do they have a plan, or is that something with the passage of this bill then that they would have to develop? And does it make sense to contemplate maybe in a second or third reading amendment, making that a condition of this bill, that it be a request in the standard budget so that we ensure that, I'm a little, don't know why I am, I just really get, there's something about those sites and when you're around them that I just want to make sure that they're protected, and I just have a sense of urgency a little bit on this, and so you can just tell me how, kind of what that conversation was, please.
Chairman Byron.
Thank you, Mr. Chairman. We did have that discussion leading up to the committee hearing on this bill, and that department certainly, the more we throw it, the more we have to talk about funding that specific department in our state that deals with the cultural resources that we have all over our state. So I agree with the good representative from over in the northwest corner, but they ultimately, in talking with that department extensively, and specifically the folks that are experts in this field, they felt like this bill was a great start. It was discussed in committee. It's hard for a lot of us to make a demand of someone without, or to make a demand of a department without a appropriation. So I certainly would be open to that conversation as we progress through the weekend, but they were comfortable without the appropriation, but we are under a time crunch. These are sensitive areas that are not only getting defaced, the weather's deteriorating them, but I think the biggest issue here, and on the bill here, Mr. Chairman, is the fine, and ultimately, the fact that people are going out and adding to this very historic, these historical pieces of artifacts, and maybe scribbling their name, and ultimately, that's a big portion of the bill, but also, I think that it's hard to make a demand on a department and not give them the resources to certainly to follow through with the demand that we put in the Green Book. So it's something that we could talk about at a later reading.
Representative Campbell Elisa.
Thank you, Mr. Chairman. Just to put at ease and answer, I guess, a few questions on page 1, line 5, you'll see on state lands. This is amending or adding to language that is already in the Wyoming statute 36.1.116. This entire statute it deals with state lands. That's it. So there's no private land. There's no land on, reservation, tribal land. It is only state lands that are being adjusted in this amendment. So,
Representative Posey.
Thank you, Mr. Chairman. I know the significance of a lot of these sites and how important they are, and it's, whether it's through the Tribal Relations Committee where one of the past speakers talked about reaching out to the tribes, and I think it's a good move. My experience on some of the cultural and the cultural sites on state land, there has been very little consultation in our tribal communities of what they mean to us and how important they are. So I think we're moving in the right step here, and I support this. I think the appropriations could be dealt with at maybe next year's session, but I know they received testimony from tribal members, and that's a good thing. So I think I support this. I'll vote aye on it, and we'll continue to move forward on state tribal relations. Thank you.
Vice Chairman Pendergraft.
Thank you, Mr. Chair. Having spent much of my life in the center of the state that's a big basin, I've found a lot of these sites and been fascinated by them and have a great appreciation for them. That said, I keep hearing weather being mentioned, and I don't see anything in this bill that is going to help with that. So if somebody could help me out, why are we mentioning weather? Thanks.
Chairman Byron.
Thank you, Mr. Chairman. The conversation in committee, if anyone would like to join TRW Tuesdays and Thursdays, downstairs, room 5. The conversation during that committee was that we have to document the current status of these pieces of artifact. Without that documentation, they don't know what somebody may or may not have done in terms of defacing it or modifying it or changing it. So the reason weather is mentioned, because there's the idea, which was pulled out in the appropriation, but the idea being, it's great to preserve and find all of these and get some actual factual data. So if the act were to take place, there would be a stronger case. Now, that being said, weather plays into that, because if we take a picture and document something today with our gusts of wind in this area, it could be gone tomorrow. A little bit of a far-fetched there, but you get what I'm getting at. Our body gets what I'm getting at. So the reason weather is mentioned is because they recognize that these change and have changed for thousands of years, but they just wanted, in testimony, they wanted to mention that because these are going away naturally, but hopefully with this and the idea of documenting them, we will find a way to preserve them for our state archives and our future.
Any further discussion? Question being called. All those in favor of Chairman Byron's motion that when Senate File 91, when the Committee of the Whole rises to report, it do so with recommendation that Senate File 91 do pass, please signify by saying aye. Aye. All those opposed, no. Senate File 91 has passed Committee of the Whole. Next bill for our consideration is Senate File 175. Reading clerk, please read the bill.
Senate File 175, sponsored by Senator Kolb. Unemployment insurance coverage, period and reporting. An act relating to labor and employment. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 175 engrossed, unemployment insurance coverage, period, and reporting, respectfully report same back to the House with the recommendation do pass with the following amendments. Ayes, Representatives Clauston, Guggenmoss, Heft, McCann, Ottman, Rodriguez-Williams, Wasserberger. Noes, Representative Yin. Representative Stibar excused. Representative Rodriguez-Williams, Chairman. This bill was re-referred to Committee Number 2 Appropriations. Mr. Speaker, your Committee Number 2 Appropriations, to whom was referred Senate File 175 engrossed, unemployment insurance coverage, period, and reporting, respectfully report same back to the House with the recommendation of do pass. Ayes, Representatives Alaman, Angelos, Bear, Haroldson, Pendergraft, Smith. Noes, Representative Sherwood. Representative Bear, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Rodriguez-Williams?
Thank you, Mr. Chairman. I move that when Committee of the Whole rises to report, it does so with the recommendation that Senate File 175 do pass, and I further move the adoption of the Standing Committee amendment.
And who will be carrying the bill? Chairman?
And I'll move the Standing Committee amendment, and then I'll turn the explanation over to the good rep, if you'd like.
Your call.
Okay, let's go over the Standing Committee amendment first.
Okay.
So, pretty simple stuff. Clean cut amendment here. On page 1, line 2, we delete renaming the. On page 1, line 2, we delete line through commission. On page 1, line 9, we delete, or after the statute 27.3102A, after 27.3304, we delete 27.3601A. And then on line 10, we delete and 27.14.802B, R, and insert is. And then on line 1, or page 1, lines 12 through 15, we delete entirely. Page 2, lines 2 through 4, we delete entirely. Page 2, lines 16 through 23, we delete entirely. And then on page 3, lines 1 through 16, we delete entirely. And yeah, pretty clean cut there. And I would stand for any questions.
Minority Floor Leader Yin on the amendment.
Yes, Mr. Chairman. So the amendment, the bill does two things. It renames the Unemployment Commission to a Reemployment Insurance Commission, and then it shortens the length of actual insurance coverage. The committee just struck out all of the renaming portion. So it was going to be confusing because even when you file your taxes, it talks about unemployment insurance. So it was just a little confusing to have it be named reemployment insurance when colloquially across the country it's understood as unemployment insurance. So that's all the Standing Committee amendment did. It struck out the renaming portion.
Discussion on the amendment. Question being called. All those in favor of Standing Committee Amendment Number 1 to Senate File 175, please signify by saying aye. Aye. All those opposed, no. Standing Committee Amendment Number 1 has been adopted. We're back on the bill. Chairman Rodriguez-Williams.
Thank you, Mr. Chairman. I'll turn the explanation over of the bill to the good Majority Floor Leader.
Mr. Majority Floor Leader.
Thank you, Mr. Chairman. Members, with that Standing Committee amendment, it pretty much wiped out most of this bill except for 2 paragraphs. So there's one paragraph on page 2 that reduces the amount of benefit from 26 weeks down to 20 weeks. And then on page 3, there's an appropriation of $18,000. That is for software programming to change the benefit. So members, there have been a number of states that have lowered their unemployment insurance down to 20 weeks or lower. Some of the states have gone actually down to 12 weeks. And what they have shown is as the unemployment rate is lowered, then you don't need as much unemployment insurance. So right now, the unemployment rate in Wyoming is 3.8%. But what they've shown is anything under 5.5, you can lower that rate. So 3.8%. Last year in 2024, the average benefit was just a little over 12 weeks. So that means there was about 92% of the beneficiaries of unemployment insurance did not use the maximum benefit. Only about 8% did that. What this is about is lowering the cost for employers while still protecting workers. It helps to put people to work sooner when jobs are available. And right now there's a lot of jobs in Wyoming with unemployment rate of a little over 3%. This is an opportunity to get people jobs quicker, provide a safety net for a little while, but it's just lowering it from 6.5 months, 6 months down to 5 months. So still 5 months of benefit, and that resets every year. So if you have 5 months off this year, as you're looking for a job, and then that didn't work out and you are unemployed again, it resets and you can do another 5, and it doesn't have to be all at once either. You can be off for 3 months, go to work for a little while, and then be off for a month, and then go to work for a little while, and be, so the safety net is there. It's a total cumulative of 20 weeks over a calendar year. So members, I stand for questions, but with the unemployment rate lower like this is an opportunity to tighten this up a little bit.
Representative Larson Lloyd.
So thank you, Mr. Chairman. I'd like to remind the body that last year we had a couple of unemployment insurance bills in front of us. And what we did was realign, the good majority floor leader noted the percentage, but not all employers pay that much because nationally, our unemployment insurance fund is, I think, the second highest of any state. It's so fully funded that most of our employers are receiving a significant discount in light of that percentage. Then, remember last year this was fun. We had to talk about the federal state unemployment insurance pool, which is what the employers pay into, and that the employees have to work for a specific amount of time to be eligible then to get unemployment benefits. And then, because in days gone by and in Wyoming making the good decisions that they had, there was a time when we had a state uninsurance plan, and we've got that. I'm trying to remember the amount, but then last year, that setting there fully that's funded in the event that the federal one ever dropped to a level that would have to impact the employers, we could draw on this, and we keep the employees protected. Now, our good majority floor leader makes a valid point in that not all of our employees that are unemployed are taking advantage of 26 weeks. And our state has been very fortunate to pick back up and have a lot of jobs. But the other side of that is the jobs that we have in Wyoming, due to the nature of them, oftentimes through a period of time will be unemployed. And so your employee that's unemployed, if you want to keep him, you can have him job attached, right? But if they're not job attached, then they can go out and so I think there's a fair argument to say that the vast majority of our unemployed employees who are eligible, not entitled, but eligible for unemployment can then have it for the 26 weeks. I'm not sure that so to cut it back to 20 weeks, is somehow going to benefit the employers and our federal unemployment account, I think that there's a real argument to say I don't think that unless the committee heard something from that agency that said that, but I think that fund is really well situated. And because we don't have that, so many of them aren't applying for 26 weeks, it makes sense that we keep it at 26 weeks for those that really do need it. So I would throw that argument out there, and I think that I would like to see us keep it as it is.
Representative Filer.
Thanks, Mr. Chairman. Hey, folks, there's no doubt a few years past that we went through a pandemic or whatever we all want to call it. There was a time that people weren't going to work, and we extended unemployment benefits. The federal government even came, or that other upper government above us, kept a lot of these benefits going for a long time. And there's this big outcry of people just sitting at home and not working and collecting these benefits. Well, we're past that now, folks. We do have a very low unemployment rating right now, and we moved beyond that. So right now, we took everything back to where it was, or 26 weeks here in the state, which it's been for a long time. And now we're just going to lower it to 20 weeks without an actual real reason why. Good, our unemployment rate's low. Okay, good, that means nobody's drawing off the benefits, so what are we worried about changing it for, right? Let's keep the weeks the way they are. May save money to employers. Well, I can tell you, I've watched my pays that goes into those actually decrease heavily. So when we look at unemployment benefits, a lot of people also look at it as, well, you got fired, that's why you're getting it. Well, no, it's not just being fired, it's being laid off. If we look at our state as a whole, our construction season is probably one of the shortest in the country. Whether you're working on roads, building houses, building commercial buildings, it doesn't matter what it is. When that ground's frozen, people aren't working. I can promise you that. And if you have a really bad winter, we might need this 26 weeks. Let's also look at what else happens in this state. We have a very heavy industry state. Say somebody gets hurt at work or in their vehicle, they have to have a surgery. After maybe their short-term disability benefits run out, they're going to start collecting unemployment, but they need a little more time off, get that physical therapy to work on their leg, their back, their neck, their arm, whatever it might be. But they might need that 26 weeks. So I'm just trying to think of why we're bringing it back when it's really not a problem. Why are we taking 6 weeks for what? If we drop this down to 20 weeks, I can promise you, every person in this room, my premium to pay into unemployment does not decrease. I promise you that. It's not going to save me a dime. And I'm going to tell you, most employers, it's not going to save them a lot of money either, because we're so good in our state how we do things and people do go to work. There's not people just sitting around collecting these benefits, folks. Wyoming's a hard-working state. I see it. Because when I have to go out there and I have to try to find people to work for me, I got to almost steal them from other places, because that's how hard these people work, and we want them working here. Just like everybody that's up there in that balcony today. They're hardworking folks. And to just tell them that, well, we think that 26 weeks is too much. Well, we're just going to go to 20 weeks because somebody might save some money. No, not going to save a dime. So, folks, what I'm saying on this is let's not tell all the people that work their butts off for our state that if something, God forbid, was to happen to you, at least you can take care of your family just for a little bit. Let's not just kick them while they're down. Let's leave it at 26 weeks. Thanks, Mr. Chairman.
Representative, is that you, Representative Wiley, back there?
Mr. Chairman, finally, and thank you.
You know, I'm sitting here reading the bill, and you're going to have to explain it to me, because not only employers, I understand wanting to get people back to work. That's a great idea, right? We want everybody to have something to do. We want them to be able to be productive and help put food on the table. But the way I read this bill, and you'll have to explain to me if I'm wrong, is we're taking away a benefit, but we're still charging the same amount of premium, because on every one of my employees' checks, they pay into this. So I don't see where it's adjusting that. And I've asked a couple of times, I've been told it's automatic, but I cannot read into this bill how it automatically reduces. So if we're going to take away part of the benefit, why are these folks still going to pay into this like they normally have been for the 26 weeks if we're going to reduce down to 20? Just a question I have. I employ, several people, another contractor in the body. I can definitely tell you some of my stuff is similar to the good representative that just talked or spoke. And I don't necessarily think that the intent is bad on this, wanting to get people back going. But when it is needed, if we do take it away, it would just be wrong if we're still having them have to lift the same amount of weight for 26 weeks and only be able to get 20 weeks of benefit.
Chairman Rodriguez-Williams.
Thank you, Mr. Chairman. So I don't disagree. On and for the bill, I don't disagree that work gives purpose. It does. We heard a lot of great testimony in committee. Some of the things that stood out to me in committee that we heard was that faster reemployment rates help the trust fund, and they keep rates for employers low. The average amount of weeks that people get back to work is 12.8. That's the average here in Wyoming. And the unemployment rate is at 3.5%. Our trust fund generates about 21 million of excess revenue. So this really would move us towards a self-fund. I know there's been a lot of questions about laying off federal employees, or layoffs that have been happening on federal employees, and we did hear from the department that oversees our workforce on that. And they had reported that there were 47 unemployment claims filed recently by federal employees that were laid off. And that funding does not come from the Wyoming account. That comes from a separate federal funding. And so, again, I think that this bill aligns with what's happening in Wyoming with that average of 12.8 weeks. And we did hear from industry folks as well. There was a contractor that zoomed in and testified. And we do realize that winters are long and people are out of work, but again, work gives purpose, so on and for.
Minority Floor Leader Yin.
Mr. Chairman, thank you. So in committee, some more stuff that we heard. This has been in place since 1957. We have one of the healthiest funds in the country. Our UI rate is in the lowest third in the country. So our fund is healthy, and it's been like this since 1957. So the question is, if it's not broke, what are we doing? Are we actually fixing anything? The surrounding states, there's 2 states that have less weeks than us. Montana has 24, the state to the north of us has 24. The state to the west of us with potatoes varies between 20 and 26. Every other state around us is still at 26. The reason the other states reduced was because their funds were in basically close to debt. And so they needed to do something to change it. With a healthy fund like ours, it's not going to do very much. And frankly, no one who was a proponent of the bill could tell us how much their premium would be reduced, because it's not going to be a lot. And it also depends on the type of worker you are or the type of industry that you're in. So as one of the good representatives said, their rate probably isn't going to change. And that's probably true, because if those folks don't take more than 20 weeks, then it's not going to affect their rate at all. We did also get stats on who claims more than 20 weeks the most. And surprise, surprise, it's operating engineers and people in the construction industry, because as we heard, we have two seasons. We have construction and we have winter, right? And winter is long. And so that's who's really going to be hurt. If we reduce the 26 down to 20, it's going to be those folks that after construction season's over, because it's so seasonal, they get laid off and they still need to find other jobs. And that's what you have to do under unemployment. But sometimes they need to do it for more than 20 weeks until a new construction job in their skilled trade can actually be found. And so the risk here is that if we reduce the amount of benefits below this, again, these are benefits that they are earning by their hard work through their employer. They're going to lose these benefits. They know that they might not be able to make it through the winter. Then they're going to go to another state. Workforce is the number one concern that we've heard from our business entities over and over and over again. If we stifle, especially the construction industry, it's going to make every part of Wyoming that much harder to live in. And so with that, I'd ask you to vote against the bill. Thank you, Mr. Chairman.
Let's go to Representative Clouston.
Thank you, Mr. Chair. I voted for this in committee. You know, I'm a saver. I think this would probably maybe save the state about $2 million a year total, looking at all the numbers. The more you make, the more you get paid. The very most you can get paid is $624 a week, and that's taxable, just to let you know. Now, with our federal employees, the feds will pay that, but if we decrease it from 26 to 20 weeks, the feds will only pay for 20 weeks. So we do cut that federal benefit away as well. I've talked to 4 of my major employers, oil field, construction, restaurant, and coal mine, and all of them have asked me to vote no. They said the 6 weeks benefit is worth more to them than a little bit of money that they'll save. They're really afraid about their workers leaving the state and not getting back. So going with my constituents after talking to the people that are involved in this, I'm going to switch my vote from a yes to a no. Thank you.
Representative Larson, JT.
Thank you, Mr. Chairman. At this point, I am going to be against this specific piece of legislation. One question or thought I'd like to explore is, you know, if we do end up passing this bill and it goes to 20 weeks, and let's say a year or two from now, there's an economic catastrophe or job market tanks, and we're not in session to address that. We have to come back either for a special session, which costs a lot of money, or we have to wait until the following session, which could be months, to address this benefit. So I encourage you to vote no at this point, but if it were to move forward, I think we need to have a better discussion on having at least a ladder that these rates can climb if or these weeks can climb if the rates go higher, so, and unemployment rates go higher. So again, on and against the bill, and encourage you to vote no.
Representative Storer.
Thank you, Mr. Chairman. Wyoming was affected by the pandemic just like every other state, but Wyoming went back to work and went back to work quickly. We were under 4% unemployment in October 2021. The virus was still with us then, but we went back to work. Last summer, our rates were under 4%, we're at under 3%. Again, we have a bit of a cyclical workforce. But all of you know, what is the biggest thing that's holding us back from growing our economy? It's our workforce. It's having our workforce here. We need to be competitive, and we need to treat people well. The biggest cause of job loss is a structural or cyclical economic action. if you're reading the headlines today, you need to understand that that is exactly what's happening, be they federal or state employees. Because with our federal employees, we'll lose state employees, and we'll lose nonprofit employees, and we'll lose private sector contractors. So the timing to do this is absolutely wrong. We could be going into a recession as we see these changes, and that's another reason for doing this, for not doing this now. So I ask you to reject this. You know, really, it's a bit of a DC think tank, cookie cutter bill. It doesn't fit Wyoming. Please vote no. Thank you.
Representative Thayer.
Thank you, Mr. Chairman. Our #1 export in this state, 70%, is our people. Why would we put barriers on that? You talk to downtown merchants, you talk to industry. I sit with businesses that want to do BRE, business retention and expansion, and they cannot do it. Why would we put a barrier when it's not broken? Please vote no.
Representative Wiley.
Thanks again, Mr. Chairman. Since my question wasn't answered, I read through the bill again. So what this is going to do is you're going to ask people to carry weight. They're going to pay into a benefit, and we're going to reduce these benefits. Body, we've been leg wrestling for the better part of 2 months over property taxes and putting money back on people's kitchen tables. And for $2 million, we're going to wrestle just a little bit more of that away so you hurry up and go back to work. Again, if we're going to ask them to pay for these benefits, give them the benefit. What are we talking about again? I mean, we're kind of getting off into the weeds, and the sentiment, I understand. We want people to be doing something. We want to get people to work. We want to get people putting food on the table for their families. But this is going to be detrimental to Wyoming families. There is no automatic adjustment. This is going to have them pay for a benefit they're not going to receive. Simple as that. Please vote no for the bill.
Vice Chairman Ottman.
Thank you, Mr. Chairman. In committee, I also voted for this bill. And let me just say why. And I'm glad for all this discussion, but we need to have a little bit more about what's going on in my mind. So what I'll say here is that I've lived in the construction industry my entire adult life. I've moved from state to state looking for work with my husband. That's what we did. And so the reason I wanted to see about this is here in the state, we have lots of jobs. They were talking about the jobs that need to be filled, how many jobs there are that are just begging for employees. So in my mind, what is happening here is the powers are looking and saying, okay, honestly too, and one of the representatives talked about job attached. I've never heard that. I know when I worked for the school district and got laid off in the summer, it wasn't job attached. I had to go looking for work. And my husband was never job attached. He had to go looking for work. So maybe that's a different thing that you're experiencing. I do not know that. But what I will say is that people are going out, and it's historical, is that you look for work, kinda, and then you just wait out your unemployment. What this is talking about, and I'm not saying it's bad, because we had testimony that said, how much do you make a week? $3,500. Okay, well, in 7 months, that's $91,000. Could you budget? I had to budget when my wages changed. And so what this is looking at our state and saying, what can we do? Are there people that could go back to work and work at some of these places, maybe temporary or full-time? Are there people that are waiting for an industry to come back that's not going to come back? And what I believe that this bill is doing, and I see all of you ready to just jump on me, I understand this is a tough thing, and all these people around here are saying, I don't want to work in fast food, I want to work in the tourism industry. But what I'm saying is the bill was brought to address this issue, which we need to do. We have businesses that cannot get employees. So what is the answer? So I would just say the conversation's good. If anybody has any answers, that would be good. As far as most construction is in 7 months. So anyway, I voted for the bill. I'm flexible on it. I'd like to hear some answers. Thank you.
Representative Majority Floor Leader Heiner.
Thank you, Mr. Chairman. In my part of the state, we have a hard time finding employees. We have workover rigs that are stacked up because they can't find crews. I don't think it's a problem of lack of opportunities out there, but maybe it's in a skill that you're not familiar with. Let's go back. I've heard the comments here. If people aren't using it, why drop it down? Let's keep it at 26 because no one's using that. Well, during COVID, that was raised up to almost 30 weeks. Well, no, it was 13 more weeks. So almost 40 weeks. Now, the unemployment rate at that time was a little bit higher, but not much. How many people utilized more than 26 weeks during COVID? A lot more. Did they go, if we raised it up to 40 weeks, would there be some individuals that use that up to 40 weeks? There may be. If we raised it up to 36 weeks, would there be some individuals that use it for 36 weeks? Probably. If we left it at 26 weeks, would there still be about 1,000 people that use 26 weeks? Probably. Historically, that's what people have utilized this, about 1,000 people a year. So I think what we got to focus on here, members, is this is to help employees find work sooner than later. Let's get them back to work. They want to work. That's self-esteem. People get their self-esteem from jobs, from being able to work and provide them an income for themselves and their family. This is a safety net. It's an opportunity to help them get back on their feet and get back to work. So we could leave it where it's at. I don't think anything's going to change. We could raise it. Let's go back up. Let's go up to 39, 40 weeks. And there'll still be a few people that use that maximum benefit. So the logic of leaving it there just because nobody's using it, I'm failing to see that. If we want to lower the cost for employers, we lower that so the premium's lower. And yes, we have quite a bit of funds in there, so we need to bring some legislation to look at that. Maybe we can lower it even more because the fund it's making $21 million a year right now. So maybe we need to drive that down a little bit for employers. But let's remember, we're trying to get people back into the employment. It raises the self-esteem of individuals when they're at work.
Ladies and gentlemen, I don't know if you guys can hear it, but that faint sound is getting louder and louder, and that is all those bills at the bottom of general file dying. Representative Larson.
Mr. Chairman, that's my 68-year-old joints creaking. Okay, so I appreciate, Mr. Chairman, I appreciate what the Majority Floor Leader is saying, and I think he's right. We want to incentivize people to get back to work. I think they do want to get back to work. But I think we have to look at the structure of this federal program, which when we had to come back last year and readjust that program because the fund is so fully funded. And we even diverted more money that we were allowed to do from benefits over into the programs that help do apprenticeships and job training. And so the impact, the savings that we're saying the employers will have, because we are required to charge a certain amount to be part of the federal unemployment insurance plan. And we're at the lowest that's allowed by federal law now. Hence, that's why we took a portion of that to get into some of these training programs to train them to work on workover rigs or whatever. The job attached thing that I referred to back when we were still in business is if I knew that my good friend, my good employee here we were going to be slow for 3 months, that I could put him on job attached that say, I'm going to take him back and he could get those unemployment benefits for that period of time without having to go out every week and look for a new job. Because I've signed that and he can come back. But he's eligible because he's met the criteria. He's worked long enough to be eligible for those benefits. And so I also agree with the point that the majority of Wyoming's unemployed are not going out 26 weeks. Perfect. But what about the few of those that need to be? Why not have that available to them? And I think that in my mind is the question is I'm not understanding why we would reduce it down to 20. I'm not making the connection on how that would get them back to work sooner. And I'm not making the connection on how it helps our fund because it's so whole now. So I think I'm going to vote against the bill. I appreciate the intent, but I just don't think the mechanics get us there.
Representative Filer? Yeah, Representative Filer.
All right. Thank you, Mr. Chairman. Man, we've had a lot of discussion on this. This is a heck of a bill. And, but I did hear a lot of folks say that, we got to save up for that rainy day that you might get laid off or lose your job. But I can tell you right now, folks, we're not here to tell people how to save their money. We're not here to tell constituents how to spend their money. We're not telling them how they save for the future or anything like that. That is not our job. But our job is to make sure that we have a program that's been set up for years to protect them in a state like ours. Our state is not like many others. We have plenty of shift workers down to seasonal workers, you name it. And, it's funny, I get these heads shaking at me like I'm not lying. It's the truth. It's Wyoming, guys. But so for that to tell the people that, hey, you guys all need to go and just save your money and hope nothing happens, I'm sorry that you all had to hear that. Secondly, the premiums, this will not save anybody very much money at all. I'm telling you. I just got a text from my nephew who does all my bookworking. And I asked him what it would be if we dropped ours down to 20 weeks, what would our premium decreases? He said he'd get back to me. He said, but it wouldn't make a difference. This is a benefit that employers pay for, but we also pass that along to our employees. A lot of our employees, this is a benefit they get in their package, right? If they never need to use it, they can use this. What are we doing? Are we telling the hardworking people that's in every single coal mine, every oil rig, every soda ash mine, every refinery, every construction worker out on the road? Are we just telling them, hey, 26 weeks, too much. You need to get work faster. Trust me, those folks that work in those industries, they don't want to be laid off. They don't want unemployment. They'd rather work year round. As a matter of fact, they beg for more. Because that's the workers we have in Wyoming. I just don't understand this, folks. I know where it stemmed from. It came from COVID. I totally get that. During COVID, we had a lot more unemployment. People weren't at work. Businesses were shut down. We had to take care of our people. And that's what this country and this state did at that time. We took care of those people. And now that's all over, we're going to tell them, right now, we just need to forget about you. If you ever need 26 weeks, forget it. Should we raise it? No. I think it's a great middle ground. I think this gives that perfect timing to where somebody could get healthy or whatever they need or get trained up and get ready for their next employment. I think 26 weeks is a great number. But to say, we'll just take it down to 20, and you know what? We're gonna get you to work faster that way. I'm gonna tell you what gets people to work, folks. The right job, with the right skill set, right education, those are what get people jobs. It's not that there needs a bunch of rig hands that need help. If you have nobody experienced in that career field, they're not applying for that. Trust me, I know. I work in these heavy industries. I beg for high school kids to get out of high school and come work for me. And you got to teach them and you got to train them and all these different things. But you know where they go? They go to their other job, the ones that they want to do for a living. Not everybody's just going to lose their job and go run and be a rig hand. Not everybody's going to just lose their job and want to go run and be an electrician. It just doesn't work that way, guys. We have a low unemployment rating. Low. I don't get why. I want to tell all the constituents of Wyoming, or the legislature does, that, hey, you guys have done a great job. You're going to work. You're taking care of your families. We have a great unemployment rate, low unemployment rate. Oh, wait, and by the way, we're going to write a bill to punish you later if you need it. Well, it makes no sense. It makes absolutely no sense. Then I also heard one more thing before I'm getting on a tangent there, Mr. Chairman. One more thing said that this fund is fully funded and we might need to look into it. Heavily funded. You want to save some employers money? Let's lower their rates then. Obviously, if this fund is flush, it's got cash, why are we still charging the same rates to the employer? Give them that break. If that's what this is about, is lowering costs to an employer, let's give it to them. But this isn't how do you do it. You don't beat up their workers to do it, on and against.
Anybody else? Representative Lean.
Thank you, Mr. Chairman. My dad often told me that opportunity is overlooked because it looks like hard work. I've had the opportunity to take some of those less than desirable jobs, but it's made me a better person. It's worked on my character and made sure that I understood the value of every dollar that I was earning, which leads me to fiscal responsibility. We just heard that the state needs to backfill these folks, and we can't tell them how to budget their funds. Well, why is it our job to fill the gap if they aren't behaving with their funds? When did that become the government's job, would be my question. I am for this legislation because we're still giving out that helping hand, but we're not making it a way of life. On and for the legislation.
Minority Floor Leader.
Mr. Chairman, thank you. Members, the only argument so far that I've heard from the proponents of the bill, because one, we've heard, it's not going to save the employer very much at all. It is going to hurt the employee. The only real purpose that I've heard from the bill is that we need to shorten the timeline to give workers the self-esteem to go to work. I think that is frankly insulting to the workers of Wyoming. They want to go to work. We have one of the lowest unemployment rates that we've ever had. Post-COVID, our unemployment rate has been lower than pre-COVID. People want to work in the state of Wyoming. The jobs are there. We've heard that the jobs are there, but there's still a reason why people have this gap between 20 and 26. The number one reason are those folks in the construction industry. If we're telling them that we're not going to have this benefit for our long winter season, again, they're going to go somewhere else. Workforce is our number one issue. If we need more workers in the oil field, we need to train them. We need to make sure our kids want to come back to the state. We need to make sure that they can raise families here, not cut their benefits to give them self-esteem. Mr. Chairman, on and against the bill.
Any further discussion? Representative, I want to do it, but I'm just going to call you your real name, Representative Cannoli.
Thank you, Mr. Chairman. I think this is, the kindest manner that I can say, I think this is not a good thing. And I'm just watching some of these folks that were here, hardworking folks, business folks, doing their thing, and we're standing here saying, partly because we have too much money in this program. We need to cut back. Whatever happened to having a savings account and being fiscally responsible to do that? And we talk about helping our people every day, helping them with property tax, helping them with this, helping them with that. And then we don't feel like we can keep 26 weeks for unemployment. I don't know. I don't get it. So
Any further discussion? I can't hear you, folks. What? Okay. Question being called. All those in favor of Chairman Rodriguez-Williams' motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 175 do pass, please signify by saying aye. Aye. All those opposed, no? No. Having failed a voice call, a standing, Having failed a voice call, a standing division vote is required. All those in favor, please rise. Please be in the bar and stand still. Please be seated. All those opposed, please rise. More than 22. Having failed a standing division vote, and according to Rule 6-6B, a roll call vote is required. Chief Clerk, when you are ready, please call the roll. 175.
Allemand? Andrew? Angelos? Banks? Bear? Brady? Bratton? Brown Gary? Brown Landon? Byron? Campbell Elisa? Campbell Kevin? Chestick? Clouston? Connolly? Davis? Eklund? Erickson? Filer? Geringer? Guggenmoss? Haroldson? Harshman? Heiner? Heft? Jarvis? Johnson? Kelly? Knapp? Larson Lloyd? Larson JT? Lawley? Lean? Locke? Lucas? McCann? Nicholas, excused. Ottman? Pendergraft? Posey? Provenza? Riggins? Rodriguez-Williams? Schmid? Sherwood? Singh? Smith? Storer? Strock? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber? Worf? Repeat? Williams? Winter, excused. Wiley? Yin? Mr. Speaker, are there any changes? Brown, Gary, no to aye. Further changes? Further changes? Closing vote. Vote closed. 23 aye, 36 no, 3 excused.
Having failed a roll call vote, Senate File 175 is indefinitely postponed. The next bill for our consideration is Senate File 167. Reading clerk, please read the bill.
Senate File 167, sponsored by Senator Dockstader. Board of Chiropractic Examiners, Criminal History Records, an act relating to professions and occupations. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 167, Board of Chiropractic Examiners, Criminal History Records. Respectfully report, same back to the House with the recommendation do pass with the following amendments. Ayes, Representatives Klauston, Guggenmoss, Heft, McCann, Ottman, Wasserberger, Yin. Excused, Representative Rodriguez-Williams and Representative Stivar. Representative Ottman, Vice Chairman.
You have heard the reading of the bill. What is your pleasure, Vice Chairman Ottman?
Thank you, Ms. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 160, Senate File 167 do pass. And I further move the adoption of the Standing Committee amendment. I'll go over the amendment. Standing Committee Amendment number 1, what it did was on page 4, line 2, after the small letter B, it inserted beginning July 1st, 2026. Okay, and then just turn, and then I'll turn the explanation of the bill over to the Representative Erickson.
Representative Erickson.
Thank you, Madam Chair. I would, at this time, like to introduce to you Senate File 167, Board of Chiropractic Examiners, Critical History Record. And it is a one that's kind of, even though it's long, it's kind of easy to represent it, and a lot of the wordiness just has to be with changing it over to such a new law. The bill is specific for the purpose of protecting the public as part of their health care. On the application for the license in the state of Wyoming, it asks about criminal history of convictions. There is currently no way for the board to verify if someone has a criminal history that would prevent them from getting a license and seeing patients. The board has to take the person's word for it. Also, if there's an investigation for any disciplinary action that's taken place, this would allow the board to check and make sure that there's no other criminal issues that would cause a licensee to lose or have a suspended license to practice in the chiropractic care. This really is about keeping good players in practice and preventing others that may have lost a license in another state due to criminal issues to come and run their way into or move their way into the Wyoming system. We have had a few issues with this over the last few years and are simply trying to remedy the issue. Now, as I said, it's a little bit of a long bill, but I will explain with just a couple of highlights. Provides background checks, it provides investigations, and it has the disciplinary action available in the bill. And so to close, again, just kind of repeat a few of those things. Authorizes the board to have access to criminal records, gives them the right to do that. The license applications are subject to investigations. There is a disciplinary action comes through the chiropractic board, and it allows for fingerprinting and seeking necessary information on applicants. And end with this one. 36 states require criminal background checks. I would hope that Wyoming would join this and further this bill. Thank you, Madam Chair.
Is there any discussion on the amendment? Question being called on Standing Committee Amendment number 1. All those in favor, please say aye. Aye. All those opposed, say no. Standing Committee Amendment number 1 has been adopted. We're back on the bill. Representative Klauston.
Thank you, Madam Chair. Ladies and gentlemen, in committee, we heard from the board that this concerns that they want this. They are probably the only medical provider that are not doing background checks, they're not doing fingerprints. They've had some bad actors come into our state and they couldn't discipline them. If they would have had this law in place, this is a patient safety issue, they could have found out the history of these bad actors previously. So this is a patient safety issue. Hopefully everyone is in favor of this great law. Thank you.
Any other discussion on the bill? Question being called. All those in favor of Vice Chairman Ottman's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 167 do pass. All those in favor say aye. All those opposed, no. Senate File 167 has passed the Committee of the Whole. The next bill for our consideration is Senate File 165. The reading clerk will read the bill.
Senate File 165, sponsored by Senator Pearson. Cancellation of registration notice amendments, an act relating to elections. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred Senate File 165, cancellation of registration notice amendments. Respectfully report, same back to the House with the recommendation that it do pass. Ayes. Representatives Banks, Brown, Geringer, Larson, McCann, Nicholas, Posey, Tarver, Wiley. Representative Brown, Chairman.
You have heard the reading of the bill. What is your pleasure, Vice Chairman Tarver?
Thank you, Madam Chairman. I move that when the Committee of the Whole rise to report, it do so with the recommendation that Senate File 165 do pass. I turn the explanation over to the gentleman diagonally from me.
Representative McCann.
Thank you, Madam Chair. This is mainly just an update. The clerks asked for this. It was mainly just a one-sentence addition for when they start knocking people off the rolls for that registration, for voter registration. In addition to mailing the cancellation of the registration, they also want to be able to email it. May provide notice to the elector by email, and that is pretty much the bill. I stand for questionings.
Any discussion? Question being called. All those in favor of Vice Chairman Tarver's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 165 do pass. All those in favor say aye. All those opposed say no. Senate File 165 has passed Committee of the Whole. The next bill for our consideration is Senate File 171. The reading clerk will read the bill.
Senate File 171, sponsored by Senator Nethercott. City and Town Regulatory Reduction, an act relating to cities and towns. Mr. Speaker, your Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom is referred Senate File 171, City and Town Regulatory Reduction. Respectfully report, same back to the House with the recommendation that do pass. Ayes. Representatives Byron, Campbell, Connolly, Harshman, Jarvis, Provenza, Storer, Thayer, Wharf. Representative Byron, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Byron?
I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 171 do pass, and with the presentation of Senate File 171, I turn it over to myself. Folks, we have Senate File 171, came out of the other body clean, and we are currently, the issue that is at hand is you propose to do a new development, you put in your survey markers, you come in and you bulldoze them all, and then you have to come put them in again before you do the work. So this good little bill, all it really does is change the shall to a may and a when to an if. So I know that sounds real quick, but it really is that simple. It's taking 2 required surveys and making it, if you want, down to 1. So with that, happy to stand and answer any questions.
Any discussion? Who's bringing the amendment? Oh, Representative Weber.
Thank you, Madam Chairman. I move Committee of the Whole Amendment Number 1 to Senate File 171. What the amendment does is on the catch title. The current catch title says City and Town Regulatory Reduction. I'm when I read the bill, which is a great one, and yes, I'll be voting yes on it, and it talks about the boundary surveys, and it talks about if the boundaries of a city or town are uncertain or incapable of ascertainment, here's how you would do this with, whether it's boundaries, substantial monuments, meets and bounds. And I just felt like it would work out a lot easier for anybody who wanted to look for this in the future to change the title to Boundary Survey Amendments. With that, I would stand for any questions and urge an aye vote on the amendment and an aye vote on the bill. Thank you.
Any questions on the Committee of the Whole Amendment? Question being called on Committee of the Whole Amendment number 1. All those in favor, please say aye. Aye. All those opposed, say no. Committee of the Whole Amendment number 1 has been adopted. We're back on the bill. Question being called. All those in favor of Chairman Byron's motion that when the Committee of the Whole rises to report, that it do so with the recommendation that Senate File 171 do pass. All those in favor say aye. Aye. All those opposed say no. Senate File 171 has passed Committee of the Whole. The next bill for our consideration is Senate File 109. The reading clerk will read the bill.
Senate File 109, sponsored by Senator Brennan. Open enrollment within Wyoming school districts, an act relating to education. Mr. Speaker, your committee number 4 education, to whom is referred Senate File 109 engrossed, open enrollment within Wyoming school districts, respectfully report, same back to the House with the recommendation that do pass. Ayes, Representatives Andrew, Bratton, Erickson, Guggenmoss, Kelly, Lawley, Singh, Strzok. Noes, Representative Williams. Representative Andrew, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Andrew?
Thank you, Madam Chairwoman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 109 do pass, and I turn over the explanation to the Vice Chair of Education.
Representative Lawley.
Thank you, Madam Chairman. I bring to you Senate File 109, open enrollment in Wyoming schools. Basically, what this bill does is give permission for school districts to have open enrollment. Some districts are already doing that. It actually says they shall. I'm sorry, pardon me. I was a little bit caught off, not ready for this one to come up, but what it does is it tells us that they should provide the opportunity for open enrollment within a district. This comes into play mostly in larger districts, quite frankly. In my own district, I have small rural schools, and we don't have 2 high schools, for example, so that they can transfer within districts. So what the idea here is that one of the things that we're looking for in our own public education system is how to provide different choices for parents within the public system. So we've done that, for example, as we've done charter schools and started charter schools, which are in the public system. And it's a choice for parents where charter schools are available. But also is something like open enrollment, where there can be some choices for parents to be able to make a change within the district to one of the other schools, whether it's for purposes of the needs of that child, learning situation, or even a situation in bullying and things like that. So we have some districts that already do this, but we're asking that all districts do it so that they can there can be more choice within those districts for parents. The bill describes some of the ways that you do the processes of open enrollment, and it also then gives the districts the opportunity to make their own rules of how they might want to manage the open enrollment process. So with that, I'll stand for questions.
Minority Floor Leader Yin.
Madam Chairwoman, thank you. Not necessarily opposed to the idea of open enrollment, but I guess the question of does the district still have to pay the transportation costs of every student no matter where they are in the county? So if there's a school on the west side of town and they live on the east side of town, it's going to cost more in transportation costs, I assume. Is the district going to have to stomach that cost with an open enrollment policy?
Vice Chairwoman Lawley.
Thank you, Madam Chairman. Great question. The bill addresses that, and the transportation costs would not be borne by the districts.
Representative Klauston?
Thank you, Madam Chair. Yes, and I was just gonna, talk about that a little bit too. You remember in Wyoming, 100% of busing costs are paid by the state. So as we open up enrollment, you're gonna see increased busing costs to the state. In our district, if you do not go to your school as assigned, you are responsible for your own transportation. So our district did not feel the state should have to be paying for that. This bill does not do that. This bill allows the districts to decide how they want to handle it. Also, what this does is it takes away the local control of how each school district wants to handle the enrollment in their own town. So right now, I'm probably against this. There are methods that each school district can do to handle changes in enrollment. This is taking those choices away from that district and making them let the students pick wherever school that they want to go to.
Vice Chairman Ottman?
Thank you, Madam Chair. I just have a question. I have been told and under the impression for a long, long time that 100% of transportation costs to school districts are paid by the federal government.
Vice Chairman Lawley?
Generally speaking, that's correct. In this bill, the districts don't have to pay that, because if they were to approve a transfer, a condition of that it is in places it's already at work, usually exempt. So the parents bear the cost of that transportation when they make a transfer. But you're correct. That would be how we normally are reimbursed currently on transportation costs, is through federal government.
Question being called. All those in favor of Chairman Andrews' motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 109 do pass. All those in favor say aye. All those opposed say no. Division. All those in favor of Senate File 109 do pass, please stand. Please be seated. All those opposed, please stand. More than 12. Having pursuant to House Rule 6-6B, having failed a standing division vote, a roll call vote is required. The chief clerk will call the roll. 109.
Allemand? Andrew? Angelos? Banks? Bear? Banks, repeat. Bear? Brady? Bratton? Brown, Gary? Brown Landon. Excused. Byron. Campbell Elisa. Excused. Campbell Kevin. Chestick. No. Clauston. No. Connolly. Davis. No. Eklund. No. Erickson. No. Feiler. Geringer. Guggenmoss. Repeat. Haroldson. Harshman. Heiner. Heft. Jarvis. Johnson. Kelly.
Excused.
Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke.
Excused.
Lucas. McCann. Nicholas, excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Webb. Weber. Worf. Williams. Winter, excused. Wiley. Yin. Mr. Speaker, are there any changes? Campbell, Kevin, excused to no. Feiler, excused to aye. Further changes? Further changes? Closing vote. Vote closed. 16 aye, 40 no, 6 excused.
Pursuant to House Rule 6-6B, Senate File 109, having failed a roll call vote, is indefinitely postponed. The next bill for our consideration is Senate File 166. The reading clerk will read the bill.
Senate File 166, sponsored by Senator Pearson. Political Party Formation Amendments, an act relating to elections. Mr. Speaker, your Committee Number 8, Transportation, Highway, and Military Affairs, to whom is referred Senate File 166. Political Party Formation Amendments. Respectfully report, same back to the House with the recommendation that do pass. Ayes. Representatives Banks, Brown, Geringer, Larson, McCann, Nicholas, Posey, Tarver, Wiley. Representative Brown, Chairman.
You've heard the reading of the bill. What is your pleasure, Vice Chairman Tarver?
Madam Chairman, I move that when the Committee of the Whole rises to report, to do so with the recommendation that the bill number 166 do pass, and I hand the explanation over from the gentleman from where the water runs from the rocks.
Representative McCann.
Thank you, Madam Chair. Again, nice quick little thing. This comes down from the clerks as well as Secretary of State in reference to filing a petition to form a new political party. We're mainly just the only thing we did was change the dates. So in line 14, page 1, we changed June 1 to May 1. And then on page 2, line 5, we changed April 1st to March 1st, which gives them a little longer to petition, was the main concern. And I stand for questions.
Any discussion? Minority Floor Leader Yin.
Madam Chairwoman, I guess what's the, was there a particular party that was trying to form that had the impetus to do this? So it looks like we're moving both dates backward from the election date. So was there a party that was trying to form that wanted to get on the ballot and that the clerks were like, this is too late, we can't put them on the ballot? How did this arise?
Representative McCann.
Thank you, Madam Chair. To my knowledge, there was no specific party that asked for this. Just believe it came down from Secretary of State, and they reviewed it with the clerks, and they agreed that those were good dates.
Vice Chairman Tarver.
Madam Chairman, the clerks actually asked for this. It makes it, they needed this, so they're the ones that requested this change to make it easier for them to do their jobs.
Representative Wiley.
Madam Chairman, thank you. Just to follow up on the flying pumpkin, yeah, the clerks wanted this, and I think it actually adds an additional day.
Any further discussion? Question having been called, all those in favor of Vice Chairman Tarver's motion that when the Committee of the Whole rises to report, it does so with the recommendation that Senate File 166 do pass. All those in favor say aye. All those opposed, no. Senate File 166 has passed Committee of the Whole. The next bill for our consideration is Senate File 160. The reading clerk will read the bill.
Senate File 160, sponsored by Senator Olson. Treatment Courts Amendments 2, an act relating to courts. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred Senate File 160, Treatment Courts Amendments 2, respectfully reports same back to the House with the recommendation it do pass. Ayes, Representatives Chestick, Filer, Kelly, Singh, Washit. Noes, Representatives Brady, Bratton, Lean, Webb. Representative Washit, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Washit.
Thank you, Madam Chairman. So members, let me tell you a little story to illustrate what this bill is all about. Imagine we have a young man, we'll call him Junior, right? And Junior's been in jail 4 or 5 times over the last couple of years, and each of his crimes are low-level misdemeanors, things like disturbing the peace or, urinating in public or something. And when he's booked into jail, the nurse and the detention officers can see that he's clearly getting worse, that his mental state is deteriorating. When he goes to court, his public defender notices this mental decline, and he asks the court for a competency hearing. The judge orders that Junior be evaluated by the Wyoming State Hospital. He's put on a list, and meanwhile, he sits in jail, and his mental health continues to deteriorate. Soon, Junior is sitting in his cell, naked, covered in his own excrement, having hallucinations, and screaming at beings that no one else can see. He remains in his cell for months, waiting for his turn to be evaluated by the state hospital. Keep in mind that the maximum penalty for disturbing the peace is 180 days in jail, but most offenders don't get any jail time. They typically pay a fine and are released. Wyoming, we have a problem. It is this problem that Senate File 160 is designed to help address. Senate File 160 is not the total solution, but it's an important step in the right direction. The committee heard significant testimony from sheriffs, mental health experts, judges, and agency administrators. Few communities around the state have treatment courts. A few communities around the state have treatment courts to help offenders who have substance use disorders. Most communities do not have such treatment courts, nor do they have the volume of offenders to justify creating one. Last year, Campbell County created a pilot program based on a mental health diversion program that has been highly successful in that southeastern state down there by the Gulf of America, the furthest southeastern state. And that program in the largest city down there has been highly successful of getting these people who commit low-level misdemeanors out of the criminal justice system and into a place where they can get the treatment that can actually help them. Jail is the least beneficial and most expensive place to let these people languish. Many of these low-level offenders can return to our normal life with effective intervention. And today, we have long-acting medications that change these people's lives in critically important ways. By getting these folks out of the judicial system, their constitutional due process and speedy trial considerations are not triggered. Thus, they don't languish in jail for weeks or months waiting for an eventual transfer to the state hospital or an eventual evaluation by state hospital employees. There are 2 additional counties in our state that are eager to launch mental health diversion programs at their own expense as a way to save money for their taxpayers and to get individuals like Junior the help that they need. So that's what this bill's all about. We do have a committee of the whole amendment that I think is something we might want to talk about, but I'm happy to take questions on the details of the bill. But that's what Senate File 160 is all about without spending lots of time.
Any further discussion on the bill? Somebody want to move their amendment? Committee of the whole amendment. Oh, yeah, Representative Bratton, thank you.
Thank you, Madam Chairwoman. I move Committee of the Whole Amendment Number 1 to Senate File 160 and ask for your favorable consideration. Members, this amendment clarifies the eligibility criteria for this bill's expansion of the treatment courts to include mental health, and it keeps that definition specific to this bill. I've spoken directly with the top official of our state judicial system and several district judges, including the one who is heading up that pilot program currently running in our state, and with the executive director of the association that deals with our mental health and substance abuse centers. All of them are in support of this amendment, and it simply aligns the bill with the same criteria being used in the pilot program. I urge an aye on this amendment.
Representative Filer.
Thanks, Madam Chair. On and against this amendment, folks, and the reason why, I totally understand why we might want to try to narrow the scope, define a definition of, mental illness. But mental illness goes a lot further than this amendment. And we're also talking about low-level type offenders. And not only that, they have to be evaluated. So I would hate to take an evaluation away from a professional and make them narrow it down to a scope of a definition. So with that, folks, we do have some pretty good, schizophrenia, PTSD, all those types of things in here. But mental health is a lot further than that. It could be everything from drug abuse, alcohol abuse. It could be a lot of other disorders too. We could even take anorexia as a mental illness and a disorder. But what we're doing with this definition is we're taking that away from the professionals that actually do the evaluation and keeping them in a scope of this definition. So, and also we need this program to kind of move forward so we can get really good data. And if we narrow the scope of it, we won't have the right participation in order to get the good data to keep this going in Wyoming. And let's not forget that a lot of these folks are repeat offenders, and it costs a lot of money to go into our jail system. Those beds, it starts adding up, and the medical treatment, everything else that they get in those jails. It'd be better to, if they actually are diagnosed with some other mental illness by a professional of somebody that diagnoses people with mental illness, they would probably get the help they actually need, won't keep repeat offending, become a good member of society, and moving forward that way. And I heard that there's a lot of associations and everybody that was okay with this definition. Anybody be okay with the definition. But I think the medical professionals and the people that do this for a living should be the ones that diagnose somebody with a mental illness, not a definition. So on and against. Thanks.
Representative Kelly.
Thank you, Madam Chair. On and for this amendment. In the committee, when we went over this, We got testimony from sheriffs, we got testimony from people who are part of these pilot programs, and they attested 90+% of the people who would benefit or the people they're having issues with in the jails fall into these categories. The pilot programs are pretty much already limited to these categories. This bill would expand it beyond them. And my understanding was, with the testimony from the sheriffs, was 30 to 40% of the inmates are suffering from these types of mental health issues. There's already a giant backlog of seriously mentally ill people waiting to get into these courts. And my concern, why I think this amendment is needed, is we don't need to further clog up the bureaucratic application process by expanding it to wider definitions. We need these people who need to be immediately stabilized and cared for to get first priority. And if we don't have this amendment and we cast that wide net, we don't know what the consequences will be because the pilot programs haven't necessarily done that yet to find out. So it's very important we keep this focused to the people who need it the most, per the people in the programs right now and in working in the jails. And if it comes back that it's not a wide enough net, we can revisit it later. But right now, I'm in favor of this. Almost every state has this type of system, but it's best to keep it focused on the people who need it the most.
Representative Chestic.
Thank you, Madam Chairwoman. So if at least part of the problem that has been identified is people languishing in jail waiting for mental health evaluations, how do we know what their diagnosis is? How do we know if they qualify under this new definition? On and against.
Representative Larson.
Thank you, Madam Chairman. I fear that perhaps we're getting a couple of issues cross-pollinated here, and I hopefully can walk us through that a little bit. This bill came out of the Mental Health Task Force, and it's been about 2 years in the making. So this amendment goes in and it changes the definition of mental health that we put in place in 35-1-613, which is a much broader definition of mental health, which is really key when we got into the behavioral health redesign in how the community mental health providers can address the need for the priority populations. That's still in place. That's in 35-1-613. This bill that's before us today, you'll recall, is dealing with treatment courts. Treatment courts used to be under the jurisdiction of the Department of Health. Last year, we moved them over to the courts. The courts, looking at them, says of all of the courts we have across Title V, we need to do some fixes. The good chairman of Judicial has addressed that. Some of the key components of this bill is this effort that we talked about in that state where there's keys, is to be able to divert these people with low-level misdemeanors away from the judicial system to get help for their illness. Currently, right now, the rules use the language of this amendment. Okay? These are the people that we're allowing into this diversion program. What this bill does for titles in the treatment court and for this diversion court is simply says we're going to, for getting in there, the diagnosis, they'll still get their evaluations and diagnosis, but to get into the treatment court, it's going to be these listed here that, and until we get a broader understanding of the success and the responses of the program. Remember that, so we've got one established program and 2 others that are just getting underway. So pilots to learn, we're just putting some sideboards. The amendment is intended to put some sideboards to make sure that we don't get out ahead in front of our skis too far. So I would encourage an aye vote on the amendment and appreciate the good explanation of the bill and would ask for an aye vote on the bill as well.
Representative Lean?
Thank you, Madam Chairwoman. On and in favor of the amendment, as we narrow the scope, my sheriff told me that this would not take away his ability to continue to run the pilot program. I did check with him to make sure that was okay. I also want to reference, if we do not adopt this amendment, the 35-1-613A Romanet 8 is a condition which is manifested by a disorder or disturbance of behavior, feeling, thinking, or judgment, such to an extent that care or treatment may be required. That's a pretty broad definition, and I don't know about you, but I don't want somebody that has anorexia to be tied up from an evaluation or placed into this treatment court when clearly that is something that needs to be dealt with on a separate level. On and for the amendment.
Representative Brady?
Thank you, Chairman. I'm in agreement. I'm for the amendment, and for those incarcerated, again, like was just said, perhaps of behavior, feeling, thinking, and judgment to such an extent that care and treatment are required, but does not include addiction. So first we have incarceration, dealing with behavior equals evaluation equals treatment equals medication, is just a horrible cycle. And I would like to mention too that there's interim topic hopefully going to be picked up of the dangerous effects of psychotropic drugs. I'm for the amendment. Thank you.
Representative Webb?
Thank you, Madam Chairwoman. I got it before the definition of mental illness was read in 35-1-613. I think we need to make sure we know what we're getting ourselves into if we open this up. Vote your conscience, but I probably will be a no vote on, or I support the amendment. Thank you.
Representative Connolly?
Thank you, Madam. I'm really in favor of this amendment. I mean, I talked to our local judges in my district, and they felt like this amendment really does solidify the bill, and the treatment court very much needed. So I'm in favor of the amendment and the bill.
Representative Washut?
Thank you, Madam Chair. I'm supportive of the amendment as well. The amendment reflects what's presently in the judicial branch rules when it comes to the diversion program. And it's limited to that diversion program. So when we're talking about the treatment courts, we're dealing with people with substance use disorder, and some of those folks may have a dual diagnosis where they also have some mental health issue, but it probably not going to be one of these severe mental illnesses, okay? So I think the bringer of the amendment was very careful to make sure that this amendment touches the diversion program and it matches up with the existing judicial rules that are already in place. Now we're putting them into statute, but it does not affect the treatment court. So I'm on and for the amendment.
Representative Jarvis?
Thank you, Chairwoman. So I just quickly Googled, out of curiosity, additional mental illnesses besides for the ones that are listed in this amendment. And anxiety disorder, panic disorder, generalized anxiety disorder, obsessive compulsive disorder, eating disorders, dissociative disorders, personality disorders, and neurodevelopmental disorders like autism spectrum disorder. So food for thought. Those are in addition to what's already there. But we would be ruling all of those out as being qualifiers.
Question being called on Committee of the Whole, Amendment number 1. All those in favor, please say aye. Aye. All those opposed say no. Committee of the Whole, Amendment number 1 has been adopted. We're back on the bill. Chairman Washut.
Madam Chair, it's a little late, and just to make sure, I move that when the Committee of the Whole rises to report, it do so with a recommendation that Senate File 160 do pass. I think I said that before, but not 100% sure. Just to wrap up the bill, one of the important considerations here, we heard a little bit of discussion on the amendment, is this will allow judges to allow individuals from a different district, court district, to go to a district that does have a treatment court. And because some of our small communities will never have treatment courts, this is an important option. The district with the treatment court doesn't have to accept that individual, but if they have capacity in their program and they want that individual to come and be part of their program, they can. And I also want to emphasize that prosecutors have discretion about who participates in these programs. So with that, I ask your aye vote on Senate File 160.
Question being called. All those in favor of Chairman Washert's motion that when the Committee of the Whole rises a report, it does so with the recommendation that Senate File 160 do pass. All those in favor say aye. Aye. All those opposed say no. Senate File 160 has passed the Committee of the Whole. Mr. Majority Floor Leader.
Thank you, Madam Chairwoman. With a little bit of latitude, I would like to, if you'll allow me a little bit of latitude here. Members, I want to gauge how long you want to go tonight. We've got a number of concurrences and enrolled acts to do, so it's going to take a little bit of time. But I'm going to make a motion to close this down. You can either vote for or against. That way we'll find out what you want to do, if you want to keep going or not. So, Madam Chairwoman, I move that the Committee of the Whole rise and report.
You've heard the motion. All those in favor of Majority Floor Leader Heiner's motion that the Committee of the Whole rise and report, say aye. Aye. All those opposed say no. No. That motion passes. Division being called. All those in favor of the Majority Floor Leader's motion, please stand. You may be seated. That passes with 40 plus people. I don't remember the rest of my script.
Reading clerk will please read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 108, do pass. Senate File 107, do pass amended. Senate File 126, failed to pass Committee of the Whole and was indefinitely postponed. Senate File 44, do pass amended. Senate File 174, do pass. Senate File 95, do pass amended. Senate File 70, do pass. Senate File 38, do pass. Senate File 53, do pass. Senate File 101, do pass amended. Senate Joint Resolution 4, do pass. Senate File 57, do pass. Senate Joint Resolution 1, failed to pass Committee of the Whole and was indefinitely postponed. Senate File 34, do pass. Senate File 91, do pass amended. Senate File 175, failed to pass Committee of the Whole and was indefinitely postponed. Senate File 167, do pass amended. Senate File 165, do pass. Senate File 171, do pass amended. Senate File 109, failed to pass Committee of the Whole and was indefinitely postponed. Senate File 166, do pass. Senate File 160, do pass amended. Representatives Brown, Landon, and Provenza, Chairman.
Representative Provenza.
I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor, please signify by saying aye. All those opposed, no. Congratulations, Representative Provenza and Brown. Thank you very much. That's a lot of bills, ladies and gentlemen. A lot of work there. Okay, we are at that order of business of requests to concur with Senate amendments to House bills. First message for our consideration is message number 419 on House Bill 246. Representative Locke. Well, look at here. Representative Stivar, please.
House, oh, it's on. It was left on. I bring you message number 419 for House Bill 246, Wyoming Wednesdays. I'm going to leave it up to the body to vote your conscience. I don't like it because they took it out and only made it one Wednesday a year. Vote your conscience if you want to do the conference committee or not.
Any discussion? Question being called. We are voting on the motion to concur with Senate amendments to House Bill 246. A majority of the elected members is required. The chief clerk will please call the roll.
Allemand, Andrew, Angelos, Banks, Bear, Brady, Bratton, Brown, Gary, Brown, Landon, excused, Byron, Campbell, Elisa, excused, Campbell, Kevin, Chestick, Clouston, Connolly, Davis, Eklund, Erickson, Filer, Geringer, Guggenmoss, Haroldson, Harshman, Heiner, Heft, Jarvis, Johnson, Kelly, Knapp, Larson Lloyd, Larson JT, Lawley, Lean, Locke, Lucas, McCann, Nicholas, excused, Ottman, Pendergraft, Posey, Provenza, Riggins, Rodriguez Williams, Schmid, Sherwood, Singh, Smith, Storer, Strock, Stivar, Tarver, Thayer, Washut, Wasserberger, Webb, Weber, Worf, Williams, Winter, excused, Wiley, Yin, Mr. Speaker. Are there any changes? Geringer, aye to no. Further changes. Filer, excused to no. Davis, aye to no. Larson, JT, aye to no. McCann, Clouston. Further changes. Speaker Nyman, aye to no. Further changes. Closing vote. Vote closed. 17 aye, 40 no, 5 excused.
I don't know why that's funny. By your vote. Oh, okay.
She's a no.
She's an, okay, so, and who's your chairman? Lock chair. Okay, ladies and gentlemen, by your vote, you have chosen not to concur with Senate amendments to House Bill 246, and we'll go ahead and name the committee right now. Committee will be Chairman Locke, Stivar, and Weber. So those folks will take care of that. Let me get this marked here. Okay. Next concurrence for our consideration is message number 418 regarding House Bill 192. Representative Heiner, please.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. I can't tell over here if this thing's working or not. I bring you message number 418 and move for your concurrence on this House Bill 192, Public Utilities, Wildfire Mitigation and Liability Limits. Members, what they did is a lot of legal tweaking, which is way beyond my pay grade. They added some things to define negligence as and gross negligence, but some of the important parts, they added a preemption such that if the land use plans contradict what the mitigation plans from the utility is, then the utility's mitigation plans preempt the land use plans. They also made it so that when the utility files a mitigation plan with the Public Service Commission, and I can say those words because it's in the bill, they have to provide notice to the conservation districts and associations of municipalities and counties and all those different associations within 5 days. So the prime sponsor of this bill is in agreement, and I recommend and I vote for concurrence.
Thank you, Representative. Majority Floor Leader. Discussion. Representative Larson, JT, first time.
Thank you, Mr. Speaker. On and in favor of concurrence, encourage an aye vote. Appreciate all of the work that's gone into this bill. As you know, this was an interim committee bill, and just through the process, it ended up needing to be a personal bill. So we appreciate the work that's gone into this, all of the hours of the working group, as well as the hours put into the debate and making this bill better throughout the session. So I encourage an aye vote. Thanks.
Any other members for the first time? Representative McCann? No, you're on a different deal? Okay. Any other members? Question being called. We are voting on a motion to concur with Senate amendments to House Bill 192. A majority of the elected members is required. The Chief Clerk will please call the roll. Whenever she's good and ready.
Allemand. Andrew. Angelos. Banks. Bear. Brady. Bratton. Brown Gary. Brown Landon, excused. Byron. Campbell Elisa, excused. Campbell Kevin. Chestick. Clouston. Connolly. Davis. Eklund. Erickson. Feiler. Geringer. Guggenmoss. Haraldson. Harshman. Heiner. Heft. Excused. Jarvis. Johnson. Kelly. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas. Excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Webb. Weber. Worf. Williams. Winter, excused. Wiley? Yin? Mr. Speaker, are there any changes? Closing vote. Vote closed. 57 aye, 5 excused.
By your vote, you have chosen to concur with Senate amendments to House Bill 192. Next message for our consideration is message number 417 on House Bill 156. Chairman Knapp. Please proceed.
Mr. Speaker, I move message number 417 to House Bill 156, proof of voter residency, registration, qualifications, and ask for your aye vote. In this, they've made quite a few changes here, but very somewhat simple. Page 2, line 1, they changed something. Page 2, line 2, blah, blah, blah. Page 2, lines 3, yada, yada, yada. Page 3, line 23, whatever. But this is where they started to make some changes. Page 4, line 7, they moved from residency to citizenship. And it says if a person does not have the documents or other proof of residency specified by rule of the Secretary of State, proof of residence may be established by a signed attestation of the person that the person is a bona fide resident of the state of Wyoming. The attestation shall be subject to verification by the county clerk or the Secretary of State. After that, they include insertion of proof of United States citizenship means, for purposes of voter registration, any of the following. A valid driver's license is defined by Wyoming statute, a valid tribal identification card, a valid driver's license or identification card, valid United States passport, certificate of United States citizenship, a citizen of naturalization, United States military draft record or selective service registration card, consular report of birth abroad, an original or certified copy of birth certificate. So with that, I would ask for your favorable consideration with the aye vote on concurrence.
Discussion. Any members, first time? Representative Yin, first time, sir.
Mr. Speaker, thank you. So if anyone actually remembers a long, long time ago when we had discussion of this bill, when it was over on our side, some of that discussion was whether we let the good chief that oversees our elections create a list, or we create a list legislatively. Sounds like the body over the other side said we should create a list legislatively. And so I believe that is a good way to go. And so I do ask for your aye vote and concurrence. Thank you, Mr. Speaker.
Thank you, Minority Floor Leader. Any other members, first time? Seeing none, question being called, we are voting on the motion to concur with Senate amendments to House Bill 156. The majority of the elected members is required. Chief Clerk will please call the roll.
Allemand? Andrew? Angelos? Banks? Bear? Brady? Bratton? Brown Gary? Brown Landon, excused. Byron? Campbell Elisa, excused. Campbell Kevin? Chestick? Clouston? Connolly? Davis? Eklund? Erickson? Filer? Geringer? Guggenmoss? Haroldson? Harshman? Heiner? Heft? Excused. Jarvis? Johnson? Kelly? Knapp? Larson Lloyd? Larson JT? Lawley? Lean? Locke? Lucas? McCann? Nicholas, excused. Ottman? Pendergraft? Posey? Provenza? Riggins? Rodriguez Williams? Schmid? Sherwood? Singh? Smith? Storr? Strzok? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber. Worf. Williams. Williams. Winter, excused. Wiley. Yin. Mr. Speaker. Posey, will you repeat, please? Thank you. Are there any changes? Closing vote. Vote closed. 54 aye, 3 no, 5 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 156. Next, we have a joint conference committee report. Let me get to that. Okay, we are at that order of business of consideration of joint conference committee reports. The first report for our consideration is Joint Conference Committee Report number 423 on House Senate File number 74. Representative McCann. Please proceed.
Thank you, Mr. Speaker. What was the number? I think I have a different number. Message number 423. Okay. Thank you, Mr. Speaker. I'd like to move message 423 on Senate File 74, immunity for drug overdose reporting. Just a quick synopsis of what we were doing. There was a question on how many times we were going to allow the person having the drug overdose, how many times were we allowed to let them do it without penalty, as well as the people making the phone call. So after a robust conversation on efforts of both bodies of the bill, the House removed the limitations on the number of times a person can receive immunity. The Senate noted that their original bill had a limit of 1 time per year, and after hearing testimony, they concluded that was too restrictive, increased it to 2 times a year, and still expecting some accountability. We concluded we should recommend concurrence with the Senate's position and would ask to vote in favor of concurrence, and we left it at 2 occurrences per year. And stand for questions.
Thank you, Representative McCann. Any members first time? Representative Yin, first time, sir.
Mr. Speaker, thank you. I was very supportive of the House position. I was in committee when we made that amendment. However, I understand that 4-letter word that representative from the county we're in talked about before. I think this is one of the places where we need to accept it. And so on and for the conference committee report, ask for your aye vote. Thank you, Mr. Speaker.
Thank you, Minority Leader. Any other discussion? Any other discussion? Seeing none, question being called. Members, we are voting on Joint Conference Committee number 423, report on Senate File 74. The majority of elected members is required to adopt the report. The Chief Clerk will call the roll, please.
Allemand. Andrew. Angelos. Banks. Bear. Brady. Bratton. Brown Gary. Brown Landon, excused. Byron. Campbell Elisa, excused. Campbell Kevin. Chestick. Clouston. Connolly. Davis. Eklund. Erickson. Filer. Geringer. Guggenmoss. Haroldson. Harshman. Heiner. Heft, excused. Jarvis. Johnson. Kelly. Knapp. Larson Lloyd. Larson JT. Lawley. Lean. Locke. Lucas. McCann. Nicholas, excused. Ottman. Pendergraft. Posey. Provenza. Riggins. Rodriguez Williams. Schmid. Sherwood. Singh. Smith. Storer. Strock. Stivar. Tarver. Thayer. Washut. Wasserberger. Webb. Weber. Worf. Williams. Williams. Winter, excused. Wiley. Yin. Mr. Speaker. Stivar, excused to aye. Further changes? Further changes. Closing vote. Vote closed. 55 aye, 7 excused.
By your vote, you have adopted the Joint Conference Committee number 423 to Senate File 74. Okay, let's see, what other few things? We got a few more things coming in. Body just kind of hanging loose here, stand at ease briefly. We just got another load of cool things here that we're going to sort through, so we'll be just a few moments. Appreciate your patience. Okay, we are at that time for enrolled acts. We have one that just came in. We are at that order of business of signing of enrolled acts. Chief Clerk, our enrolled act for our consideration is enrolled act number 56.
House Enrolled Act number 56, being original House Bill 117. An act relating to water development projects, authorizing construction of designated water projects, describing projects, specifying terms and conditions of funding for projects, providing grants, providing loans, providing appropriations, amending the sponsor's contingency fund, amending amounts and terms of appropriations for specified water prior projects, transferring funds from Water Development Account 1 to Water Development Account 2, transferring projects, repealing a project, authorizing one full-time position, making conforming amendments, and providing for an effective date being enacted by the legislature of the state of Wyoming.
I'm about to sign enrolled act number 56, having been originally House Bill 117. I have so signed. That was the omnibus water bill, ladies and gentlemen. We were just discussing it. So, all right. Messages from the Senate.
Message 417, Mr. Speaker, House Bill 156, proof of voter residency registration qualifications. The House bill listed above passed on third reading in amended form by the vote indicated. Ayes 26, noes 4, excused 1. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 418, Mr. Speaker, House Bill 192, Public Utilities, Wildfire Mitigation and Liability Limits. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 29, excused 1, conflict 1. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 419. Mr. Speaker, House Bill 246, Wyoming Wednesday. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 22, noes 9. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 420. Mr. Speaker, House Bill 316, School Finance Model Recalibration 2. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 29, noes 2. The Senate respectfully asks the House to concur by adopting the listed amendments. Message number 423. Mr. Speaker, Senate File 74, Immunity for Drug Overdose Reporting. The Senate adopted the Joint Conference Committee number 1 report on the bill listed above by the vote indicated. Ayes 31. Sincerely, Ellen Thompson, Senate Chief Clerk.
Okay, anything else that needs to be properly brought before this chamber tonight? Seeing nothing, before we close out, any committee reports? Any committee announcements? I'm sorry, we just did the standing committee reports. Committee announcements? Anything? No committee announcements? Thank you. Chairman Locke, go ahead and finish that before you put something in that microphone that they won't be able to get out of. Thank you.
Okay. Sorry, Mr. Speaker, but the Revenue Committee meeting, there will be a joint Revenue Committee meeting Monday morning at 8 o'clock to hear interim topics. So.
Thank you. Chairman Andrew.
Thank you, Mr. Speaker. Your Joint Conference Committee number 1 on House Bill 86 will meet Monday, March 3rd at 8:30 in room West 110. Additionally, your Joint Education Committee will meet on Wednesday, March 5th, to discuss interim topics in Capitol Extension Room 5. Thank you.
Thank you, Representative. Chairman Washington.
Thank you, Mr. Speaker. Your committee number 1 will meet in about 15 minutes in our normal room. Just kidding, just kidding. Committee number 1, let's see if everybody's listening. Committee number 1 will meet Monday at noon recess in room 6 to consider interim topics.
You know what I love about this body is that you guys are still having fun and enjoying each other, and you're able to hear a joke and enjoy it and stuff like that. I love it. I appreciate the 68th House. Any others? Any other announcements from our good committees and their chairs? Seeing none, Chief Clerk, does that clear the deck? The deck is cleared. Good majority floor leader, please release us.
We don't want to go back into do something else?
Do you want to go ahead and do something else? Feeling froggy, are you? Well, whenever you're ready, John.
All right. Mr. Speaker, thank you. I move that the House adjourn until Monday, February the 3rd at 10 a.m.
March what? March 3rd, yep.
Sorry, we changed months, didn't we? And we'll have to change our passwords too for our phones. So March 3rd, Mr. Speaker.
Thank you, good majority. You've all heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Congratulations, ladies and gentlemen. You've just completed the last day of Committee of the Whole of your first year, as many of you members. You've done a tremendous job. Bless you. Give yourselves a hand. Good job, good work, well done. We will see you all safely, I trust and believe, back here Monday morning, 10 a.m., and we will take this up again, and we will do more incredibly good work for the people of the state of Wyoming. You have a blessed and safe week. Thank you. House adjourned.